Wait, your lordships. Back to mention item numbers 8 to 12 of the hearing list matter. I have some personal difficulties today. One of my colleagues that passed away yesterday.
Oh,
To
okay.
be there, yeah. Can it be after 2 weeks, ma'am?
2 weeks, okay. But Mr. Deepandi, learned counsel for the appellant, who has prayed for adjournment of the matter. It is not objected by the other side. Okay, so in view of the above, list the matter after 2 weeks.
Right.
You want a date?
No, madam.
Okay, after 2 weeks.
How late?
May I, Your Lordship? Lordship, I beg to mention item number 6 and 7, Your Lordship. This matter may be listed.
When do you want it?
No, I am appealing for the appellants in this case.
Hmm.
If not inconvenient to the court, my lord, can it be on 2nd of March?
Okay. Mr. PGA, the same learned counsel for the appellant is present along with Ms. So-and-so, learned government advocate for the state respondents. On the prayer made by the learned counsels, list the matter on,
2nd of March.
okay, 2nd, 3/20/20.
Bless Your Lordship.
May I please, my ladies, I beg to mention item number 13 and 14. I've
Hmm.
taken consent from the other side.
Hmm.
Can it be listed after 2 weeks?
Mr. So-and-so, learned.
Item number 13 and 14.
Yes, learned counsel, now in 13 it will be for the appellant, okay? And then in, okay, it's all listed together, analogous, okay. Learned counsel for the appellant has prayed for adjournment of the matter with the consent from the other side. In view of the above, list after,
2 weeks.
you want a date?
No particular date, after
Okay,
2
list
weeks.
After 2 weeks.
Highly obliged.
Item number 1 and 2.
Yes,
But pleasure. But although the matter has come up for admission, by earlier order dated 22/10/2025, observation is there for disposal of the matter at the admission stage.
we'll list it some other date.
Madam.
We'll list it on some other date.
Right.
What is the matter about? This is concerning joint verification. The learned single judge had disposed of the writ petition. So the judgment is in favor of the petitioner, is it?
The judgment
Except for a small part.
small part. So only that part, whether the third party can be bound by an agreement, where my lord, the third party is not a signatory. my lord. So
Who
that's,
is the third party here?
my lord, I am the third party. The agreement was between the BRO and the my lord, principal contractor.
Okay,
So BRO trying to impose the condition of that agreement on me, the subcontractor, who is not a party to the agreement. And
you
therefore,
were a party in the writ petition?
I was the writ petitioner there.
Writ
my lord.
petitioner.
Basing on the my lord, provision of section 70 of the Contract Act, I have my lord, filed the writ petition saying that I have lawfully executed the work and they have been delivered and the BRO has been enjoying. So therefore, all the 3 ingredients of section 70 satisfies, and therefore I am entitled to the compensation that or the price that supposed to my lord receive. The Honorable Single Judge accepted my lord, that proposition and directed that the all pending bills will be paid directly to the petitioner, not to the principal contractor.
So that's in your, this thing.
So that
your
is in my
favor.
favor.
What
And
is
accordingly,
the
they
other part?
have paid also to some extent, but so far as the damage, etc., or the realization of fine damage, etc., for that the Honorable Single Judge has said that I should go to the civil court. Now, this question of my lord, deduction of damage or etc., these all, my lord, comes from the agreement that was executed between the BRO and the principal contractor. I am not a party to that. So therefore, the terms and condition of that agreement cannot be imposed on me. my lord. various judgment of the.
So you're praying for compensation for the damages also? No, who's praying for compensation for the damages?
My lord, as a subcontractor, I have executed, I was my lord, allowed by the BRO to execute 49% of the work as a subcontractor.
Hmm.
And while this approval was granted, there is a specific condition that all the responsibility and the terms and condition of the my lord, principal contractor will be on the principal contractor.
Okay, but now so now it
No-
says
Now
that,
contract has been terminated, so therefore they are trying to my lord, realize the damage, etc. from me. I am the subcontractor. BRO is free to realize from the contractor, not from the
okay, the
subcontractor.
respondent, one of the respondents or what? The damages? Who is the BRO?
BRO is
Made
Border
a
Road
party, made a
Organization.
party,
Yes,
he's a respondent in the,
yes, yes. They are the
Okay.
principal respondent. They had in
Okay.
fact my lord, issued the NIT and they have my lord, issued the LOI to the my lord, principal contractor.
okay, so it should not be from you, but from the
But from the
principal
Lordship, my lord.
contractor.
Because the agreement is between the principal contractor and the BRO,
Okay.
Border Road
Okay,
Organization.
now what is the submission to be made by the yes, respondents? Do you agree with his appeal? Who's representing BRO, huh?
My lord.
So
Okay.
who's representing the principal contractor?
Nobody, my lord.
Why not
Nobody-
made a party?
My lord, yes, we had made a party my lord, in the, before the single bench, my lord.
Huh,
He did not contest.
huh.
He did
But
not
in
con-
the appeal,
In the appeal also, we have my lord, made party, but they did not my lord,
notice complete-
respond. So the
let's see.
names
Because
of,
then he has to be heard, isn't it? The
no, my lord,
principal
the
contractor.
principal contractor name has been my lord, deleted.
Okay,
Lord,
we shall take some for 6 and 7.
not sure.
6 and 7,
Deleted, my lord.
deleted. And then allowed to be deleted?
Lord,
Where?
Lord.
In the IA or what? Where is it deleted? Because then,
Because if it's not to be recovered from you, then it has to be recovered from the principal contractor. That's what you're saying.
Lord.
but here there's an IA. In the IA, 6 and 7 allowed to be
Strike off.
struck off.
Lord. Because they did not contest the my lord, before the honorable single judge, my
Okay.
lord.
So can we just allow the appeal then? Because your basic, this thing is that you want to be compensated for the damages, isn't it? So in the appeal, he says that it is not for the appellant to pay for the compensation, but it is for the damages, isn't it? But it is for the principal contractor.
Malad, Lordship, peruse the Malad, order passed by the Ladet single bench, Malad.
Mhm.
It is at page number, Malad, 544, Malad. 544.
So you feel that it has to be this thing, the appellant who has to pay
The-
for the.
Malad, this requires no interference, Malad.
Okay, because, no, wait, no, from the order, I'm just reading the order passed by this court on 22/4/2025,
Madam.
isn't it?
Yes, Malad.
Here,
Operative portion is, Malad, page number 44,
uh,
544, wherein, Malad, in paragraph 24, it has been specifically,
so wait, I'm just trying to understand. So the judgment says that for compensation of the liquidated damages, compensation, etc., you have to approach the civil court.
correct, Malad.
It doesn't say that the petitioner the appellant has to pay, isn't it?
No, my lord, that's what-
Now let's see, because I'm just trying to reason out if the single bench says that the liquidated damages or whatever can be claimed before the civil court. It doesn't say that you have to pay for the damages, but that the BRO can go to the civil court, is it? To claim for the
Malad,
damages, is it?
it is the appellant who has to approach before the civil court, Malad, not by the, Malad.
Because the learned single judge says that it is the appellant who has to pay for the damages,
Madam.
is it?
Altogether, Malad, 3 directives were, Malad, passed by
Okay,
the
okay.
single bench.
Hmm.
They are happy with the first one and the
Hmm.
third one also, Malad.
Hmm.
And they are basically, Malad, not happy with the, Malad, second direction, Malad.
Hmm. if so advised.
Well, during the pendency of the appeal, they have deducted the
Oh, okay,
damages,
okay, damages from you.
etc.
That's
Now-
why you want to recover the amount, is it?
This,
Which was deducted
so,
from
so
your
far as
amount,
this has, so far as the liquidated damage, etc., these are all governed by the terms of the agreement. So that agreement was between the BRO and the principal contractor.
So,
Therefore, they are not authorized to deduct any amount from me. So therefore, the honorable single judge ought not to have relegated me to the civil court for realization of those damages if are deducted. Because my contention is that BRO do not have any power and jurisdiction to impose this liquidated damage or realize any damages from me. Because there is no agreement, there is no PVT of contract between me and the subcontractor and the BRO. So if you have to deduct anything, you deduct from the principal contractor, you go ahead, I have nothing to sue. There is a
no, so the plain reading of this, I'm reading from the order passed by this court on 22/04/2025, okay? Wherein the directions given by the learned single judge has been listed out. Okay, 1, 2, 3, 1, 2, and 3, the three directions.
Gotcha.
You are unhappy with the second one?
Second
okay?
one.
Now, concerning the second one, the learned single judge simply says that the civil court will look into the matter. You, approach the civil court. It doesn't say that you have to pay
Gotcha.
the further damages.
Gotcha.
So I think your contention, what you're making today before this bench, should be made before the civil court. Whether you have to pay or not.
Civil court would come, my lord, when question of, my lord, there appeared that the question of factual question need to be determined by the court.
Questions of facts. Is it?
If that comes up, in that case, this court will not be the court to adjudicate that. Now here, it is a purely question of law, whether the third party to an agreement can be, my lord,
Okay, so in the
brought
agreement,
under-
it's clearly mentioned that it is the principal, the contractor who has to pay for the damages.
yes, that is, they have an agreement to that, my lord. They have an agreement.
Okay, let's see the agreement.
My lord, the agreement, of course, it is not annexed here.
They have already deducted.
Now, after the judgment, my lord, taking this, my lord, clue of this particular direction in two, till then they had not realized, but taking advantage of this, my lord,
Now they have
direction,
realized.
they have realized, my lord, during the pendency of the appeal.
Oh, they have already realized.
They have already realized during the pendency. Now, my question is that BRO has no power and authority to realize this damage, etc. from me. There being no agreement between me and the BRO. That is my simple contention, my lord. If they can prove that they have the power and jurisdiction to, my lord, deduct, my lord, I will be relegated to civil court. But otherwise, my lord, if they fail to do so, that they have any power, in that case, my lord, they will not have any, my lord, power and
So
jurisdiction to
we'll have
deduct.
to look into the terms of agreement.
My lord, so far as I am concerned, it is only, my lord, my approval is, lordship will kindly see.
Yes, you're this thing, how are you included? You're
I'll
the
just-
subcontractor,
Lordship,
isn't it?
Lordship will kindly come to, my lord, page 88.
Or will this for the next? Yeah. Okay, now, see, today, the matter, instead of us hearing the matter in the last court date, let's just see. Hmm. Can we fix a different date? Because it needs, I think, a hearing proper in the admission stage, okay, but we will say that an attempt will be made in the next court date. Okay. Because
Otherwise, that is
this
the only
bench is
thing,
going to
Smaller,
set
if
only-
they show, BRO can show that this is the agreement or this is the clause by which they can realize the damage, etc. from me, I have no case. But if they fail to do so, then this direction or the deduction, that will be
But that has to be studied, okay, the agreement looked into.
logical.
Okay. Now, the problem is this bench itself is going to sit only for tomorrow. And it cannot pass a reasoned judgment within such a short time.
Logical. Understood.
And even if it's made a CAV, the files will have to be carried. And I will be attending another bench, in
Logical.
another
That is
station.
there. That is there.
So a little bit problem will be there. If we could just dispose it off with maybe 1 or 2 pages, it's okay. But on hearing your submissions, it appears that we have to look into the agreement and pass a slightly more long reasonable judgment, which in this short period, it's not
Madam.
possible. If this bench was sitting in the next week, it would have been okay. We could have heard and given some time to write the judgment,
Exactly.
isn't it?
Yes, I know.
So maybe in the first early week, next week, early date, so that the bench can sit for a longer time.
In that case,
Oh,
I'll be praying
At least
for,
2 weeks' time is required
Right.
for the same bench, huh? Yes,
in
when
that
do you
case,
want it?
I'll be praying for a date, in the first week of March only, because some constraints are there.
Okay, first week of March, we'll make it on a Monday or a Tuesday. so
Tuesday,
that
my
at
lord,
least
3rd of March, my lord.
3rd March.
That's it.
Okay, 3rd March, huh? Mr. P.J. Saikya, Learned Counsel for the appellant is present along with Mr. M. Kato, Learned Deputy SGI for respondents number,
My lord, all the respondents.
for the respondents. On hearing the submissions made, this court find it appropriate to adjourn the matter to 03/03/2026, wherein an attempt will be made to dispose of the matter at the stage. List on so and so for admission hearing.
Madam, I'm sorry, I voted respondent number 1 to 4, madam.
Okay, 1 to 4.
I'm for
And-
respondent number 5, Your Lordship.
Mr. Government Advocate for respondent number 5. Yes.
Madam.
Item number 3.
Yes. Yes, concerning the road.
Yes, my lord. There's a PIL regarding, my lord, the tardy progress in the construction of the road was supposed to be completed 7th of December 2024. We are in 2026 now, January.
But I think there's some extension of time till this, in
Yes,
the
extension of time till
additional
July.
affidavit was supposed to be filed. So
Yes,
in
my
the
lord.
additional affidavit.
Government may have to say something today.
Government had given some time, it appears, till which date?
31st of July 26, Milords.
This year.
Yes.
And
If your lordship permit, Milord, before going into the
Yes,
matters, Milords,
huh.
if your lordship sees your lordship's last direction, Milord, I must first comply with that, Milord. But there was a direction of personal appearance, Milords.
Have they appeared?
Yes, Milord. One of them has come, Milord.
The director of so and so, vice president, Mr.
Yes.
I shall remain present.
Milord, directions were in respect of 3 persons, Milord. Milord, so far as if your lordship,
Who is present today?
Mr. Abhishek Kumar is present, Milord.
Okay.
Milord, Mr. Khare, Milord, we have indicated in our affidavit file yesterday, Milord, that he is not keeping well, so he could not come. And Milord, time and again, your lordship has directed for the presence of the director, who are the main person concerned. But unfortunately, Milord, he had met with an accident with a private aircraft accident, Milord. Luckily, he survived. If your lordship would kindly have a look at my affidavit file yesterday, Milord.
Okay, next some pictures.
Yes,
in
my
the
lord, if your
affidavit.
lordship is page 730, my lord. Few days back this happened, my lord. And at page 733, if your lordship sees,
Hmm.
Mr. Serial number 3 is Mr. Sunil Agarwal. So, my lord, he's been currently under medication, my lord. He's hospitalized in Fortis Hospital in Mumbai, my lord. So I'm praying, my lord, so far as this part is concerned, my lord, let your lordships exempt his personal appearance. And so far as Mr. Khare is concerned, my lord, he will appear on the next day, my lord, because he has to comply with your lordship's order, my lord. He was there on last occasion, my lord. And Mr. Abhishek Kumar is there, my lord.
Abhishek. Okay, so what sort of an accident is this?
My
7:30?
lord, it was a chartered flight, my lord.
Ah, chartered.
That
Okay.
got, luckily he survived, my lord. If your lordship sees
Mhm. Yes,
that
okay.
it happened somewhere in Odisha, my lord.
Hmm.
So first, my prayer is, my lord, your lordship may examine the personal appearance of the director. And for Mr. Khare, my lord, he could not come. Lordship may direct that he may be appearing on the next day, my lord. And
Well, Khare is due to ill health, you
yes,
say.
yes, my lord.
But any medical this thing?
No, we could not, my lord. Yesterday, that's why there was a delay of 1 day in filing this affidavit, because your lordship has directed to file me by 20th, my lord. Because of his situation, my lord, we could not ascertain. Yesterday, my lord, he informed that he is not in a position to come. Otherwise, he was scheduled to come, yes. That's why, my lord, 1 day delay, my lord.
Anyways, next.
But
Then
so
what
far
are
as-
the other directions of this court?
My lord will see, there was also a direction as regard the certification part of the work, my lord, because your lordship has observed in the order that there has to be a certification. So we at our end also do at page 728, if your lordship have a look, my lord. This is one of the tests, my lord, we do my lord, by employing a third party agency.
Hmm.
And my lord, there was, so that my lord, where the question was raised as regard the, my lord, the quality of the work. And your lordships in the last order has observed that the moth has to make that exercise, my lord. If your lordship sees at page paragraph 12 of that order, my lord. My lord, we, so far as if you,
Yes.
yes, my lord will see the first direction. Respondent number 7 shall place on record a detailed deployment chart of manpower, machinery, equipment actually stationed at the site within 3 weeks from there. The shall be immediately verified and checked by the committee. May I indicate to your lordships, my lord?
Who's the
A
committee?
committee of lawyers have been constituted by your lordships, my lords. They have to submit a report after verification, and I have to place on record, my lord, the chart. But in this affidavit, we have annexed the chart of that machinery. Now your lordship would,
So, but is it checked by the, has it been checked by the
my lord,
committee?
that committee
And
report,
who's
my
the
lord,
committee? The committee is, what are the thing? Councils for the
Eh,
petitioner?
no, my lord, our councils represented, my lord, councils, advocate lords who have been
Okay.
constituted by this honorable court, my lord.
So, the same shall be immediately verified and checked
So,
by
my lord,
the
that
committee.
verification, I also take your lordships to para, 3, A3. Respondents, the pillars and structural works constructed shall be subject to certification of quality by an independent third-party expert appointed by MORTH.
Hmm.
So the MORTH also has to carry out this exercise. And then again, if your lordship would see,
They have not taken steps.
No, no, a
Let's hear from the moth.
a quality assurance report covering pillars, road layer, DBM, drainage and flash work shall be submitted within 3 weeks. This quote is that substandard pillars, if any, shall be rectified or dismantled. So, my lord, a very strict direction has been issued. But that is subject to the report, my lord.
So who's going to make
Moth-
the report? Moth?
MORTH, yes, my lord.
So Moth, who's representing ministry? Yes. Have you looked into this matter or? So you have to check also certification of quality by independent expert. Have you
My lord,
appointed an independent expert?
no, my lord. My lord, I haven't any instruction. It's because my lord, the officers who follow up the case, he has been already transferred to the Delhi, my lord. So because of the communication gap, my lord, we could not, my lord, reach to them. Ma'am.
So, the part which has been to be played by Moth has not been done, isn't it? Because then simply filing an affidavit that we have done this, but which is not cross-checked
Cross-based, my lord,
by the
that
concerned
exact-
committee or by a committee formed by the MOT, whether it's substandard, whether it is okay, etc., isn't it?
my lord.
The quality has to be checked. So if that is not done, then again here, the fourth sub four,
My lord,
MOT shall examine the alleged excessive subletting.
my lord. But-
Is there excessive
No, no,
subletting,
Lord.
which we denied in your
Yes, yes, yes.
affidavit, I
But what
think.
they say, Lord, under the contract, we have 49% that we can
Oh.
subcontract that we have done. But earlier also affidavit has been filed, which is there on record, Lord. Anyway, your lordship has directed for a fresh exercise of that. So they will have to carry out.
So
But I have
MOT
one,
will have to do their
yes,
homework
yes.
here,
Yes,
isn't
yes,
it?
Lord. But I have one prayer for
yes.
your lordship's
Mhm.
consideration. Lord, though I am representing respondent number 7, Lord, but I also understand my role is also an officer of the court, Lord.
Hmm.
It's a fact, Lord, that there has been delay in the project. There is no doubt about it. But and because your lordship has been monitoring these issues, much development has taken place as of now. And Lord, Lord, we have one issue, Lord. What has happened earlier, the extension was not granted. At that point of time, Lord, a direction was there, the extension of time for, Lord, the payment for the escalation would not be given, Lord. Now they have regularized my extension till 31/7.
Hmm.
But, Lord, the payment has been withheld, Lord, to the tune of around, Lord, 7 odd crores, Lord, that we have indicated. And, Lord, there are for maintenance work also, Lord, payment has been deducted, which we have consented. Now, Lord, your lordship would see if such a big amount has been blocked, Lord, there would be definitely
But,
problem for us.
But listen, for your works, you have answered the tender, you
Well-
have, that means you have sufficient funds. You
That's
cannot
true.
Depend on payment to be
No, no,
made
no,
for
Lord,
continuation
but
of
the-
your work.
I am, no, I am not.
Then,
What I am seeking is, Lord, the work I have done, which has been verified, which has been detained by the authority. Lord, it can't be that the entire amount I put it in one go, Lord. Lord, the mechanism is such, I'll do the part work, they will release my running bills. That is I'm asking, which I am entitled to in terms of the contract. Lord,
Okay,
may I pray,
but-
let them respond
Okay,
to my
yes,
queries.
Yes, that is one of your this thing. I think
I know, Lord, I am in a,
the
in a
department-
PIL, yes.
the
But still,
MOT
since
will
your
also
lordship is
have
observing
to-
all these issues,
will have to also.
well, let
reply
them
to
file
that.
a response to it,
Isn't
Lord.
Yes.
And well, we are
Concerning
trying at our
bills,
best,
running
Lord, that the
bills,
matter should be
Extension of
extended.
time you have granted till.
31st July.
Yes, yes.
Come to that, with
Mhm.
regard to that.
Which one?
Third party testing,
Ha, 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 ha.
that in our report by the executive engineer, the MOT has appointed a third party expert, Malak, and they have done the testing. The report is yet to come.
Okay.
Okay, so we'll wait for the report then.
Malak,
Huh?
further, Malak, as for the last
Huh.
order, Malak, we have made a submission
Comes.
before this
Uh-huh.
that we may be allowed, we may have the liberty to take action against the contractor. Malak, we'll see.
Hmm.
The work was awarded in the year 2021. The
Hmm.
appointed day, 2020, appointed day to start the work was December 2021.
Hmm.
And the completion, original period of completion was 7th of December 2024.
Okay.
Now- Because of the pendency of this PIL and we have extended the time up to 31st July 2026.
Hmm.
Now, remaining, we have only 6 months, madam.
6 months.
5 months.
Oh. Okay, now.
Now, 5 months only remaining, my lord.
Oh.
5 months remaining, we have till date. Only 48% of the entire project has been completed. And it is, now we have come to the conclusion, it will be impossible.
Hmm.
This, even if we wait for the the last date of extended period, Pranat, it has become impossible for them to complete the work.
Hmm.
They will take another 4-5 years. So, in the gulf of this PIL, if this honorable court gives them the liberty to continue with the execution of the work, we will be unable to take action against them. So no positive direction to execute. It will be at liberty to them whether they want to, if they can complete it within this time period.
Ah,
But
July.
in the meantime, we may also be given the liberty to go ahead with whatever action we want to take.
What action are you planning to take?
We are
You
planning to
cannot
terminate the
withdraw
contract
it.
itself because
No.
it has become.
You cannot terminate because you have given them time till July.
My lord,
Okay? So
there-
you have to patiently wait till July and then we'll see after
my lord,
31st July.
there is a procedure.
Okay, uh-huh.
There is a procedure. It is not that we will have to wait till the date of completion, extended date of completion. If we have come to know that there is a progress, this part. If they don't, if they fail to achieve that target, then also we are
Okay, you've, that if you.
the milestone. If there are suppose there are 4 milestones.
Hmm.
If the completion date is 31st of July, if they are yet to even achieve the second milestone out of the 4, are we not entitled to go? Yes, that liberty may be given.
File an affidavit regarding that if you want an order on.
My lord,
Let's see.
my lord, that
For
in fact, my lord, this is a PIL. We may just be given a liberty that whatever action the department wants to take, they are at liberty. Only that observation.
Not required. See, now here you're saying that Mott, the Mott has yet to file this thing, committee, make a committee. So now the learned additional AG says there is already a committee, is it? What is the committee?
Not
which you
committee, my
mentioned?
lord.
Then what?
That is
No,
independent.
no, PWD. Now PWD will examine this excessive sub. This is the order. Okay, so PWD department, the 4th one. I'm reading from the last order direction of this court. Okay, the first one, the first direction we have to
Yes,
see
sir.
whether this has been
Roman 4, your
complied
lordship is
with.
referring to.
Yes.
Yes.
So in the Roman 4, they are going to see regarding the excessive subletting
Yes,
allegation, find out.
yes.
Okay, this maybe in a form of an affidavit, whatever you have, whether there is excessive subletting, which he says it's only what,
49%.
49%. Okay. Then the first one, it's a committee. So the committee will have to furnish their report, the first one. Committee consisting of a group of advocates, I'm told, okay, which there's no report. Then how much will be required? Now, the A. So paragraph 1, small a, what the respondent number 7 shall also clarify how much machinery and manpower will be required. Where's that your affidavit? Have you mentioned that?
But the exact number of machinery we have not mentioned. We
Yeah.
have stated the number of machineries we have deployed. And we say we have some other issues also, my lord. Since your lordship would kindly
Wait,
take note of.
let's see a reply to
Yes.
that.
My lord.
We will first see whether the direction of this court previous order was
Yes, yes.
followed or not. Then any new.
Yes, yes,
We'll have a
my
look
lord,
at that. So 2A, machinery and
Yeah.
manpower required. Where have you explained that? Para? Judge's report is there.
My lord. Para 22, my lord.
What do you say in para 22? Huh?
And that,
Please read.
your lordship would also read with para 14, my lord, with the list of machinery that we have given here.
1-4?
Yes, yes, yes.
Okay.
And the page 714, my lord, a detailed list of manpower and machinery deployed at site is enclosed. More than 70% of technical staff are deployed. So we have provided a list. Now your lordship come at para 22. But it is something like this, my lords. But there are structures that has to come up, my lord. For that, I cannot employ or deploy machineries at this stage of time. Therefore, we have stated, my lord, that the list of machinery has been enclosed in compliance with the directions. It is clarified that the existing machinery is sufficient for the present activities and manpower shall be further augmented in line with the coming superstructure and launching of works. But as and when the work progresses, my lords, that's how, my lord, we have to deploy them, my lord. As of now, my lord, it is not practically possible to indicate before your lordships, my lords. And that is even the present one is subject to, my lord, confirmation by the committee, which we have deployed, my lord. So, my lord, my friend has raised an issue, my lord. We also have issues to raise, my lord. It's a public interest litigation, my lord. So, my lord, the entire emphasis is on, my lord, the completion of the work. My lord, in terms of the contract, my lord, there is a stipulation that 90% of the, my lord, project work, project land and all should be provided to us. That we have given on 1710, my lord. There are issues between us, my lord, no doubt about it. But that should not, my lord, lead to, my lord,
Okay,
termination of my contract at this stage.
There's this flyover.
Yes,
at Nahar.
my lord, my lord.
What I noticed when I first came was that no work was being done. Everything is clear, clean, but no workers present. I thought you had stopped the project.
No, it's not that, my lord.
Exactly, man. I have not said anything till
But it's
nothing,
the-
my lord.
Gone.
And that is why that at paragraph 2,
Hmm.
the order, my lord, of the directions shall also clarify how much machinery and manpower. That is something I have been insisting all along. And they are not replying to this. What is this?
But why is there no work? I thought.
I didn't say anything
Swami,
because I was
you
hoping
said
that they should
the work has
terminate
been
their
stopped.
contract.
It's continuing, is it?
Yes, yes.
I think everyone can see it.
Yes, no,
Yes,
Lord,
nothing is there.
still we have progressed up to 50%, Lord. Lord, Mr.
What?
Kumar is there.
I was
No
staying
work
quiet.
done.
And every time they are before this honorable court,
Yes,
I don't
yes.
want to say this lying.
Please explain why it appears that nothing is being done. I thought you had stopped for some time. New contractor must have been appointed. That was the impression we get.
It is not like that,
Hmm.
Your Lordship. Actually, before coming to that point, I would like to highlight one more point. Time and again, it has been said that in 2024, it was the completion date and it is extended. The extension is given not because of my fault. The extension is given because the land was not made available. In fact, we are the sufferers due to this delayed in handling over the
So
land.
what do you mean by land is not available? The road is there.
No,
What
at
land
this-
do you need?
At this point of time, it is available. But the extension was given for the project delay, extension was given just due to land was not available, ma'am. So it was not our fault that the extension is given.
90%, Lord.
And as per contract agreement, 90% land has to be given, then that day will be considered as the appointed day of that project.
And that did
Okay,
not-
whatever. Okay, land. So now can you explain why no work appears to be done in that day? No
Okay.
workers, nothing. It's all clean.
No, ma'am, it is the work in the kilometer, foundation number 25, 26 has been going on. From the last, we are deploying a new gang. Actually, the coming to the answering this question before that, there is severe, cash crunch going on. We are putting our running bills. Generally, what happens, you put running bill today and within 5 days, you get the payment. But the whole thing is prolonged for weeks and months, ma'am. Ma'am, last month on around 22nd or 23rd, we put in the bill. We finally got approved around 10th or 12th of this month. For
So
20,
you got your money.
we
Wow.
got
Running bills paid.
partial money.
Wow.
For 20 days, it was delayed. That could have been made in 5 days. And generally, it is happening in every project. EPC mode project, running bills, they don't delay or hamper. But it is, for what reason it is being hampered? And we have invested so much in this project and we have a cash crunch. We depend on the rotation of the funds. And the whole thing is stopped that. And second, coming to, even if the payment is made, there are some EOT, which has been already been given to us till 31st of July. And for that, 10% money is withheld. Then again, for maintenance work, they have 50 lakhs, every bill it is held up. So it is being tried to create a cash crunch. And somehow, I don't know, I won't say that thing, but this is how it.
May I record his statement? There is a cash crunch and we are deliberately trying to solve it. That we will answer, I will reply to
See,
that.
but
Yes,
one thing
my lord may
is-
record
Wait,
that
wait.
there, and that they are having a cash crunch.
Ultimately, we are the sufferers.
No,
No.
it's okay.
It's a
We'll sort,
300
we are
crore,
hearing it.
more than 300 crore project, and they are trying to complete it only by the running bills. They are trying to complete it only by the running bills, what they are going to be paid. What sort of
I
contractor
got
is
your
that?
point. You have to be, you must be a experienced contractor working with the government for many projects. Okay. It is not always the case where the government will release running bills immediately. Okay. Because the government also has their constraints concerning money. It's always an issue. So when you when you bid for a certain tender, you have to ensure that if the tender and the money involved is huge, you have to ensure that you have the finances to be able to complete. Simply giving an excuse that running bills were not crash crunch, that means you are not fit financially.
Yes,
it
ma'am.
I would
appears-
like to reply that. Ma'am,
Depend
that is
only on
exactly-
running bills.
That is exactly the reason. They are unable to. Even today, if this court, honorable court says that, okay, everything is clear now, the deadline is on 31st of July. Let them to have the undertaking that we will surely complete it on 31st of July.
No, let's
Otherwise,
see.
give us the liberty
You
to go ahead.
see,
No.
so what happens is the contractors or persons who bid also have to be a bit careful that they don't bid for too many projects. Otherwise, then they will have this problem. If you have too many works at hand, then this thing, so you have to make sure that you are capable of completing. They don't
I-
depend only on the running bills. Then you
Just wanted to point
maybe
out-
you've invested in some other
Let me-
project, but you have to give your priority and complete those, especially the PILs. Then other projects, whichever because usually experienced contractors will have many listing works in their hand. Then they bid for too many works, and then the problem rises, isn't it? Anyways, so you have explained that.
If I may point out one thing, your
Uh-huh.
lordships. This is where I've been harping upon this for a long, long time. My lord, as a layman, what I see, these pier cap shutterings that they have to, for the purpose of putting in the cements and all, so that these structures, pillars and all come up. They have 3 of them. There are 149 pillars. I, as a layman, made a calculation. If they have only 3, it takes 5 years, man. 5-7 years.
Anyway, that's his responsibility. They have extended to this extension of time, 31st/7. Was it the date? Was it on your request, or it is by the grace of the whatever the government that they said, okay, we'll give you more time, or was it on your request for extension?
No, they calculated it that we, as per the land available and all those things, will give you 31st July as the completion date. And ma'am, as he said, Rakesh Saab said, till on 17th October 2025, 90% land was completed. 90% land was officially given to us. So we will be requiring a extension of time, further extension of time for a few months, at least for the execution of the
Anyway, let's see. So 90% on which date?
1710.
1710, 2025.
So look into this matter, okay, the government, whether this is correct or not.
And
Yes, okay.
I would like to highlight one more point, ma'am. As you rightly said, contractors should be capable enough to handle the projects. But coming to that thing only, so initially we had invested everything. This is how the project runs. Initially, you pay for the BG, you invest for the machineries, and everything is accounted. And the project depends on the running bill. I mean, slightly here and there. If it is
Running bills are always delayed.
Uh.
If you're experienced, you'll know that.
generally in the moth control projects, it is on time, ma'am. Generally on moth project, in state funds, there is a delay, but central funding, it is always on time.
Anyways, so this is one of your points which maybe they'll reply to or check.
Yes.
Okay, look into the matter.
My lord, the appointed day was 8th of December 2021. What they are trying to impress upon this honorable court that if 90% of the land is given, then it will be the appointed day. What the date said by his 10th of December
17th October.
17th of October 2025. This PIL itself was initiated in 2024. And at that point of time, they never said that our appointed day has still yet to come. They have never said that. Now they are taking this plea
Oh,
and 90%. What the rest of the portion they are doing?
Okay, anyways, so the land available, I think. maybe-
Everything is
maybe you
available.
will break up as to 90%.
They are just
So what
making
are the other
excuses of-
percent, when and how is the land available at that time completed?
Can I
isn't
respond
it?
to your
Ha,
question?
ha,
For a
ha,
moment,
ha.
clarifying my friend's stand.
Ha.
Lord, it's not that we are not interested in blood executing. Otherwise, my lord will also see one aspect of the matter. When we start a project, my lord, our man, machineries, all are deployed. There is a cost incurred. But if there is a delay, we also get Lord, in difficulty, we also incur losses. What we are saying, Lord, when going contractually, it's not that we have not started we have started the work, but there has been hindrances. And there are orders in which your lordship has also recorded that.
Hmm.
So, Lord, if technically speaking, Lord, one goes for that, Lord, then appointed date should be counted from that day when 90% land is clear. Not what we are saying. We are not saying that we have not started the case.
Okay, okay,
Work.
but that's one of your explanations, huh?
Madam.
Okay, so basically we'll pass an order, but
Madam.
by the next date, the reports which
Yes,
is
my lord.
required to be submitted by the committee.
Committee, as well as from the
One
most, my lord,
committee and Moth, look
My-
into the matter.
my lord.
And the financial aspect, you can also explain what are the running bills, when were they paid?
Lord, we have in
The
our
delay-
affidavit,
where?
Lord, we have stated, my lord.
My lord,
Hmm.
these financial aspects, my lord, because there are many things to be explained, my lord. They just claiming by the.
Let's see the
Yes.
affidavit, where's the
But I'm not
affidavit?
saying that your lordship should pass an order immediately as
yes,
such.
yes, yes.
Because your lordship has to see the balance from both
Yes,
sides.
yes.
Only I'm indicating, Lord, we also have difficulties and we are in a public interest litigation before your lordship, Lord. It's not that only one party would be heard.
So where's this thing explanation regarding the financial crunch that you're mentioning?
Yes, my lord. My lord will kindly come to paragraph 17,
Page,
18, your lordship,
page,
page 715.
hmm. Regarding the subletting, the committee has to look
Yes,
into it.
para
So
18
we
is.
will not
Yes,
see
yes,
this.
para 18, my lord.
Yes.
That the observation regarding LS failure to honor the primary and continuing constant affecting errors to timelines have been acute financial distress and caused by arbitrary and contractually impossible withholding of payment, despite extension of time having been duly sanctioned. It is respectfully submitted that there exists no contractual provision whatsoever permitting withholding or recovery of EOT related amounts in cases where delay is attributable to delayed handling over of the land by the authority. On the contrary, the contract expressly contemplates grant of EOT without financial penalty where delays are not attributable to the contractor. Pursuant to the approved extension of time, the project completion date stands fixed at so and so. Accordingly, milestone falls on so and so. Until the milestone date is reached, no deduction or recovery on account is contractually permissible. That notwithstanding the above, the authorities has withheld substantial sums on account of EOT detailed as under so and so. So, my lord will see it comes to 7 crore 52 lakhs, my lords. And there is a retention money also in next page. We have said we have also issued bank guarantee. The authority is already holding substantial security in the form of retention money to the tune of 7 crores. There is bank guarantees to the tune of 10 crores. Our finances are also been involved in the project. It's not that we are coming without any finances. Let them respond to this also, my lord. Say if they are looking into only how the adversarial part of it, they must also see our difficulties which are there, my lord.
Okay, we'll pass the order today.
My lord.
Anything else?
My
Yes.
lord, these matters, these disputes are not subject matter for adjudication in this PIL, my lord.
This is my petition.
Yes,
Yes.
of course, my lord.
What
When-
the contractors are, if they are,
No, they're explaining the matter.
my lord,
So,
explanation is what,
as called for her.
two explanation by the contractor is why the delay. One is that we have withhold some running bills.
Yes.
The second is that there were obstruction and the appointed day if technically it was from
Hmm.
October
7,
2025.
October, 2025.
These are the only two explanations they are given. Prior to that, what were they doing?
Okay. Yes.
And now,
Huh.
if even if we say that we have the right to, we have rightfully withheld this payment. Now, if we give them this payment, whether they will be able to complete it in on the
Yes,
deadline?
Yes, we have
No.
given them time.
They are just making excuses. It has become impossible. These are lame excuses just to cover up their delay.
Why it's impossible, my lord? One
Anyways,
thing,
huh.
may I just,
Huh.
by it, I have not said anything.
Mm-hmm.
I was really hoping that this does not get terminated and they continue their work.
Mm-hmm.
In fact, I've been talking to my learned friend also, Mr. Dubey, in fact,
Hmm.
Mr. Abhishek also. In the hope that once it gets terminated, they will get into litigation with the government, all these things, and the work will never be completed. But now, after hearing what submissions that is coming from them, I think these are only delaying tactics, because initially, during the suburbans, the contention was, it's a rainy season. When the work season is started, now they are starting this. That is unfortunate, I'm sorry.
No.
Anyways,
My friend
Rainy
has all the
season,
right,
also
Lord,
this
to-
rainy season,
Lord,
now when the working season is here, now they say that money not given, that given.
now
What is
rainy
this, my lord?
season is coming up. Okay. So before the rainy season, you have to work full force. Let's see. Then after
We have
seeing,
2 months left. March,
after
April, your
seeing
lordship
the
come.
way you are performing,
hardly any time
Ah.
now.
Yes.
we'll have to see the way you're
Well,
performing.
So
Definitely.
many affidavits are filed.
We
Every
expect
two
the work to go
during
in
the
full
summer,
swing.
your lordship, the only
Okay.
thing was rainy season.
And even
After
the
October, it is
public
this.
and the petitioners have to be satisfied that you're trying and putting your best to complete the work.
That is
Because
exactly,
right now,
I said
right
personally to Mr. Abhishek on the last occasion.
Right now, it is very quiet,
Mm.
the stretch.
Not only the
Nothing is being
contractor,
done.
I told my learned friend
Ah.
also.
Uh,
At least show us something.
See, you're saying some pillar somewhere work is being done. What about the others? You don't wait step by step. Go full swing.
We are planning that, ma'am. Actually, what we-
Planning,
We have been
start
planning
without
for
planning.
2 months.
No.
Because
Actually,
whoever plan,
our intention is by May, we will complete the whole highway work. I mean, nothing would be left beyond
What
May.
about the flyover?
And the flyover, since the land is only given by 17th October, it will,
anyways,
My lord will.
whatever it is,
Not-
we have to be satisfied
My lord.
that you are giving your best, attempting to complete. And then we will see whether you're really sincere. Now, the impression that we're getting is that you're not really sincere in your work and just playing delaying tactics. So that impression has to go.
Exactly. ma'am.
Okay.
So my lord,
Because rainy season, whatever, we don't know how the monsoons is going to react. We cannot expect you to be a Superman or whatever to complete even working in them. But we have to be satisfied that you are really trying to complete. Things are there, progress is visible, which is not so right now. Okay. Really, because the first impression after coming here was that, oh, they have stopped their work. Maybe someone else been appointed. Nothing to be seen. Okay, that's the thing. So anyway, the petitioners also, you see how it's been now. Now we expect some work
My lord.
by the next court date. And then the committees also, please.
committee's report. must-
Yes, a report is
Next
required.
direction.
Yes.
And if I may pray, my lord, the paragraph 12 direction, the respondent should clarify how much machinery and manpower will be required for completion of the project. That they will have to come up with on the next occasion, my lord. My
More,
lord,
more
that
detailed.
direction.
Now, yes,
not even
machinery,
replied
you're
to that.
saying it's not possible as the work. But the present work, what you are doing, that has to be reported.
That will indicate in our next.
In a more detailed
My lord,
manner,
my lord.
because it's slightly vague.
And then the report of that third party expert also.
Yes, that,
All that is required.
my lord.
So,
Why would
anyways,
they not say what is the number of machineries required to complete the work? What is this? They're obviously
because
evading, my
they're
lord.
not working.
That's why
No,
nobody is there, your lordship.
So work.
We'll explain that in our affidavit, my lord.
Why
work
didn't you
and-
explain it this time
Yes,
then?
no,
No,
work,
it's not, my lord.
work and then show
is
us
this?
how much machinery you are actually deploying.
They're pulling
that
more
we
out
have-
of our
That
hands.
has to be shown.
But actually, what we have deployed is there in the list. That has
Ah.
to be, my lord, examined by the committee.
Yes.
That's been,
And then maybe you should increase also.
yes, my lord, that's-
Because you have very
And my lord,
little time now.
next time they will indicate how much machinery will be needed, my lord. My
Will
lord,
be
kindly,
needed and is being
yes,
deployed.
yes.
Okay, increase.
yes,
Maybe it's not enough, isn't
my
it?
lord, that will be.
Anyway.
Apparently, my lord, is
Yes.
not enough.
Heard Mr. So-and-so, learned counsel for the petitioner. Also heard, Mr. So-and-so, learned counsel for respondent number 3, comma, Mr. So-and-so, learned additional AG, and Mr. M. Mato, learned deputy so-and-so. Okay. Having heard the submissions made by the learned counsels, the affidavit dated, this is dated
21, my lord.
20/01/2026 is perused by this court, wherein the learned counsel for respondent number 6,
7, my lord.
respondent number 7 submits that the directions made by this court by its order dated 24/12/2025 has been taken care of. Full stop. We have perused the affidavit filed by the learned counsel for respondent number 7 and find that though the respondent number 7 has made an attempt to explain and address the direction made by the by this court, we find that there is not enough detailed explanation regarding the machinery, is it?
Yes, my lord.
And the manpower deployed for the works. Full stop. We also find that the respondent number 7 has tried to explain the reason for the delay due to financial difficulties caused by delay of the payment of the running bills. And where's that explanation, para?
Para 7,
Financial.
para 18.
18,
Yes,
yes.
my lord.
And for
Para 18 and 19, my lord.
withdrawing, withholding or recovery of EOT. Give it the full form of EOT.
Extension of time, my lord.
Okay. Permitting withholding or recovery of EOT related amounts by submitting that a total of rupees 7 crores 52 lakhs 45,069 has been withheld on account of EOT. Full stop. No, EOT, which has created financial crippling to the project. Full stop. The Learned Counsel for the respondent has also submitted that as per the direction of this court, the committee is to file the verification report and the MORTH, okay, Ministry of so-and-so, is also required to look into the matter by an independent
Third party.
third party to look into the quality of the works constructed, quality of the pillars and construction works made by the respondent. We find that there is no such report submitted by the committee or the committee, independent third-party expert appointed by the MORTH. In view of the above.
My lord,
My lord, regarding personal appearance also. you
that-
know,
my lord, may kindly also observe that we may be allowed to explain the withholding of that amount of.
Yes, yes. In view of the above, this court finds that the committee who is to verify regarding the deployment of manpower, machinery and equipment actually stationed at the site, and also the independent third-party expert to be appointed by MORT is to furnish their report by the next court date. Good stuff. This court,
Lord, serving
the
a copy to us,
submission.
my lord. At times we are not served, my lord. Service a copy
this
to
court
respondent.
on the submission made by the learned additional AG find it appropriate that the
PWD may.
PWD may also file an affidavit with regards to the claim made by the respondent number 7 regarding the withholding of the what money,
Yeah.
Yes, my lord.
money slash
Bill.
running bills.
Running bills.
Yes, running bills. Good stuff. Anything else?
Lord, the personal appearance, my lord.
Oh, no, besides that, any other thing we
My
require
lord,
besides
my lord,
the personal appearance, huh?
the department may be at liberty to act as per the contract agreement.
But that, my lord,
My lord,
observation.
that
my lord,
is a contract agreement. We are.
If they are there, that liberty is
no,
not
no,
required,
no,
my lord.
no.
Yes.
Otherwise, lordship is adjudicating the issues once.
Not at this stage, okay? At
Let
the
it come on
next
the
stage,
next
huh?
stage,
You
lord, when they
file
find it,
report
we'll also
at-
respond to it, lord.
My lord,
The-
this, we are bound by the contract agreement.
The-
We,
the learned edition AG also submits that the PWD department may be allowed to what?
act in accordance with the contract agreement. That
Act
is
in accordance with the
contract agreement with
agreement
the contractor.
with the contractor. This court, however, finds the submission made a bit rather vague and may be explained as to what steps they would be required to take in an affidavit, if so advised. Okay. Okay, it is also seen that
But that is always open to you, no?
Yes.
Yes,
Even if the
my-
court doesn't say anything.
no, anyway, so
that's why, if,
an
because
affidavit as to what steps, if so
So
advised.
that we also have a right.
it's, my lord may only observe that it is open for the department to act as per the contract agreement. That is only the
Nobody
thing.
has tied their hands, my lord.
That is only the observation we have.
That observation, lord.
No, but what steps you're planning to take, etc.,
let them
so that
explain.
no
My lord,
litigation is not caused and no complication, because
My lord-
this
my lord-
PIL is a matter which we
As
consider.
my lord has said that it is always open, but once we start taking action, they will again take that lame excuse that they are taking action, so we have stopped.
No, what action
That's
you're
why,
planning
only
to
the
take,
observation that,
you get instructions first, you get this thing as to what you would be doing,
well,
because
then that
it is-
observation,
Uh-huh.
we may be at liberty, that itself may be struck off, my lord. We'll take our own action without liberty.
Okay, you don't want to make that submission, no, leave that, okay, has also played that part, okay? That, because, we'll see, okay, because we have to see how both parties.
Because
let them give
we are
them a
bound
time.
by the contract
You
agreement.
see, because you have given leverage till 31st/07.
No, that is also
That's
conditional.
why, that is there in the mind, though we will not
That is also
record
conditional.
everything in writing, okay? Yes, then, the presence of Mr.
Mr. Sunil Agarwal, my lord.
Sunil
Lord, there was a
Agaru.
direction to 3%, sir.
Okay, it is seen that who is present today?
But Abhishek,
Mr. Abhishek Kumar, he is representing,
Representative of R7.
R7.
okay, representative of R7 is present today, while it has been explained that Mr. S.K. Kare, Vice President within brackets contractor, is not able to appear today. Why?
Because of his ill health, my lord, that he.
Because of his ill health. However, there is no medical certificate to support the said claim. Therefore, the director of Shivam, Mr. S. Kare.
No, he's not the director.
Okay, therefore, Mr. S. K. Kare, Vice President, within brackets contractor, is to make his personal appearance
On the next day.
positively in the next date. It has also been explained that who's in accident?
Sunil Agarwal, the director, my lord.
Okay, Sunil Agarwal, the director of Shivam, is not able to appear today due to an accident which occurred on
Few days back, my lord.
a few days back, and
He's hospitalized.
documents to support that claim has been enclosed in the affidavit. Therefore, the immediate appearance of the director is waived for the time being.
My lord.
Full stop. Matter to be listed again on, give me a date.
10th of February, madam.
Okay, by that time, committee report everything.
Yes,
Is it?
my lord will observe that the copy of the order be furnished to the chairman of
Lord,
the advocates.
Can I
Committee,
pray for
Mr.
16th, my lord?
Mr. Tissot.
It's on 16th, 02/20.
Not on 16th, my lord.
16,
No, no. There's for 3 weeks. Let it be on 10th, my lord.
Well,
Let
let
it
it
be-
be-
no,
No, see, you're insisting on a short date, but in the meantime, you are also required, the committees
My lord.
are also required to file their report.
Today is, my lord, 22nd.
So if
5
you're
is
able,
2
if the this thing committee is able to furnish their report,
they
that
would be
is
able to,
the
madam.
advocate, then
This-
we will list, because.
This
by the
honorable
next
court, my lord,
meeting,
by an order earlier,
hmm.
had already directed this matter to be listed every 2 weeks.
That was an earlier order,
Yes.
my lord. It was there, my lord, but
So
under
no,
different
because we
circumstances.
want a report
Yes.
from the committee.
Yes.
Simply listing it again in a short date, and there is no report as per
Madam,
the
let's
director.
try on.
Report, my lord.
You will be, you will.
I
be
don't know
listing-
why the contractors are submitting like this.
No.
No,
Let
no,
let
no,
it be on 10th.
Party respondent here, my lord, I have a right to submit.
You have a right to submit.
Yes.
Delay it.
no, now.
No,
the
it's not a
date-
question.
But no,
Let
the
them,
date-
let them file. I also have a right
No,
to
no.
respond to what my
The
friend
date-
files.
The date has to be fixed so that the committee reports are available.
And my lord, I can also
That
respond.
is after 2 weeks.
That's
Why-
why
10th of-
let it
yeah.
be fixed on 10th.
10th, they
Yes.
will be able to submit the report,
yes,
that is
yes,
okay.
yes.
List on 10/02/2026.
Can it be on 13th, my lord? I'm just staying for 3 days, my lord.
Why, what happened?
There's some difficulty on 10th on my part.
Okay, he
That's
cannot
all.
Not
appear.
on
Okay,
Friday, not on the Friday.
no,
Not on
wait.
Friday.
Why, what happened
On
on a Friday?
Friday on the last day in a bench.
That's why I was saying for
everybody knows what
16th.
happened.
16th is a Monday.
Let it be on 10th.
No,
Or
we'll
11th.
make it 10th, then let's see.
Then Monday, my lord, I have some difficulty.
It's
That's
not a
That's
Monday, it's a Tuesday.
No, my lord, on 10th, I
It's a
said.
Tuesday.
On 10th.
10th is a Tuesday.
Let it be 11th then, my lord.
Okay, on 11th, list on 11 to 2026 for the committees
For one
so
year.
constituted to file their reports. Yes.
problem हुआ है. Otherwise,
On 11th, okay,
Man,
yes.
okay.
no.
These contractors, matter from outside, they think this is a money-making machine.
Lord, I also can make some submissions out of record, my lord. It's not that.
This is exactly that.
They want copy to be served, the committee,
Deeply.
Subcommittees of this, this
copy
thing,
to be served.
to be served to the committee so constituted.
Committee, you were saying, who was the?
Yes.
Con-
Name.
No, name.
Name.
What,
That
what?
name. T-son.
T-son. Okay.
Lord, may I request the report of the committee may be furnished to us, respondent number 7, Lord.
Let them, the thing.
Lord, many a times we have not been furnished. That's why, Lord, I'm making this prayer.
It should be done. So if it's not done, you submit in the
Fine.
next court.
Deeply.
Okay? Mhm. Yes.
Item number 4.
May I please, Lordships? Lordship, this matter, last occasion, On 3/11/2025, TCR was called for from Larned Trial Court.
TCR, right?
And Lordship, in my IA, I have also filed IA for suspension of the sentence. So in IA, I have also filed one additional affidavits by enclosing all the medical documents of the convicted person.
It is under which section?
Well, it's like 376. No, he was not convicted in POCSO. In fact, charge was framed under section 4 of POCSO and with section 376.
Six, I think, the victim informant needs to be heard.
Yes, he was.
Yeah, he's
Oh,
here,
okay,
he's
okay.
represented, isn't it? Legal
Yes, yes, ma'am.
counsel. So, your TCR, no, yeah, this thing, AI. From your submission.
My lord, yes,
because of medical.
it was the
medical
month of-
report has been called.
Yes,
Now,
ma'am.
medical report, he is now at the moment stable,
It was,
nothing wrong, then how can we?
my lord, it was the month of November when report was called from the Central
Now-
District Jail Authority.
Then we'll.
Now, from the month of November, he was sent to the District Jail Teju, my lord, from zero. So now he's in District Jail Teju. So there also he's facing same health issues, my lord, by bleeding from blood and blood bleeding from mouth
Okay,
and
then we'll
nose.
get the distinct status report from Teju.
Exactly cause of the disease not detected in the district, the hospital authority, the
Oh.
jail authority.
Very strange is all the accused persons, they are healthy when they are outside. The moment they're in jail, they have so many complications. So we have to see whether it's genuine or not. Okay.
Yes, my lord.
Because before the incident, there will be nothing concerning his ill health, everything. Only once they are in jail, they have so much complication. So we'll call for the, waiting for the preparation of the paper book, we'll also call for this thing, latest health status
From
report from Teju.
District Jail Teju, yes, ma'am.
Okay. Heard Mr. N. Rama,
N.
is it
Rama.
Learned Counsel for the appellate. Full stop, also heard Ms. So-and-so, learned additional PP
Yes, Lordship.
for
Eligible.
the state respondent and Mr.
M. Lego,
M. Nebo, learned legal aid, is it?
respondent number 2.
Counsel for
Respondent.
respondent number 2. The learned counsel for the appellant has prayed for the disposal of the interlocutory application by submitting that the appellant may be granted bail due to his ill health. Full stop. We have seen that this court in its order dated 03/11/2025 had directed the jail authority to furnish the current health status report of the appellant, wherein the current health status report of the appellant as on, where's it?
10th November. Then
Just a second. I was looking at it just
10th
now.
10th November 2025.
Yes, wait, for that I'm looking for. That's on 10/11/2025, shows that he is currently stable.
Physically fit.
He is currently physically fit and stable at the time of the examination. Full stop. The learned counsel for the appellant submits that the appellant has been transferred from which jail?
My lord, 0 to District
From
Jail 0 to
uh,
Teju, District Jail
District
Teju,
Jail 02
Teju,
Teju
Lohit District.
District Jail, and submits that the appellant is facing a lot of health issues now at District Jail Teju. Full stop. In view of the above submissions, this court find it appropriate to direct the jail authority at District Jail Teju to furnish the current health status report of the appellant on or before the next date of listing. Accordingly, list, or we'll fix a date on,
Least after, my lord,
So that at least the jail authority will
Yes.
expedite the matter.
My lord, it may take some 10 February, my lord. 10 February.
10/02/2026. So is a copy of this order required to be given to this thing?
Yes, Lordship.
A copy of this order to be duly furnished to the this
Jail.
jail authority, district jail, Tejo. Okay, registry to do the needful.
Yes.
Now, in the main criminal appeal, it is seen, okay, again, Mr. So-and-so, learned counsel for the appellant is present along with so three of them. Okay. It is seen that TCR has arrived. It's a paper book to be prepared at the expense of the appellant. Let's again, same date, list on 10/2.
Apply, Lordship.
Much. Sir.
Item number 5.
I apply to your lordship. This is, we are challenging the impugned order dated 03/9/2025. By that impugned order, the accused was convicted for 20 years and 3 months. Here, we have filed 2 IA. One is for the suspension of that conviction and sentence order. Another is for the condemnation of delay. That is 67 days.
To do the condonation.
Yes, the condemnation of delay.
IA number
IA 2.
two.
Yes.
Condonation first,
How many days?
67.
Yes, will allow.
Lordship, if Lordship deems fit, Lordship, if
Yeah.
they have the enough ground to condone the Lordship.
Allow.
Yes.
Simple,
And it's
criminal
a statutory appeal.
Yes, Lordship.
Appeal will allow. Heard Mr. So-and-so, learned counsel for the, in the IA, okay, applicant. Along with Ms. So-and-so, learned additional PP and stuff. It is saying that this application is filed under section 5 of the Limitation Act, 1963, praying for the condonation of a delay of 67 days. In filing the criminal appeal against the impugned judgment and order dated 03/09/2025, passed by the learned session judge, UPIA, in session case number 13/2021, corresponding to WPS case number 06/2021 under section 376 IPC, read with section 6 of the POCSO Act. Stop. The learned counsel for the applicant submits that the delay of 67 days have been explained at para 3 of the application, which is beyond the control of the applicant being sent to jail after his conviction and sentence, and therefore needed time to contact a counsel. Full stop. Ms. So-and-so, learned additional PP, in all fairness, submits that she will not be filing any written objection, this being a statutory appeal. Full stop. Having heard the submissions made by the counsels for both the parties, we have perused the explanation given at para 3 of the condonation of delay application and are satisfied with the explanation given. Stop. Accordingly, the delay of 67 days in filing the connected appeal, criminal appeal
Yes.
number
02/2020.
2026 stands allowed and disposed of. Stands allowed, full stop. Accordingly, IA number 02 of 2026 stands allowed and disposed of. Now, after that,
Main appeal.
the main criminal appeal.
Yes, criminal notice has to
Mhm.
go to the
Notice
response.
all of
Will issue
the
notice.
Yes.
heard Mr. So-and-so, learned counsel for the appellant who has filed the instant appeal against the judgment and order of the special judge within bracket, POXO, close bracket, comma, UPIA, in Itanagar WPS, same, copy paste the previous one, okay? Under section 376 IPC, read with section 6 of POXO Act.
And 506 of IPC.
Okay, yes, comma dated 03/09/2025, wherein the appellant was sentenced to undergo, where is the sentence?
It's in the para 83, para 75.
Yes.
It's page 82 and 83.
Undergo,
20 years.
20
ah,
20 years.
undergo rigorous imprisonment for 20 years and pay a fine of rupees 20,000 on his conviction under section 6 of POXO. And sentenced to undergo 3 months for commission of no, on his conviction, okay, under section 506 IPC.
Yes.
Stop. Both the terms of sentence are to run concurrently. Along with a default clause, okay, just make it, along with a default clause, full stop. Appeal is admitted. Issue notice to the respondents, Ms. So-and-so accepts notice, additional PP accepts notice on behalf of the state respondents. Notice is to be issued to respondent number 2 through registered post with AD within 3 working days, returnable by 3 weeks. Okay. On a POXO, but then, no, true, we can do that, but you have made them a party here.
Yes.
isn't
Yes,
it?
we have met.
So, you know who they are? Can you, issue notice to registered post also?
Lordship, through the office of
Through
public
the office of
prosecutor,
PB.
Lordship.
Okay, issue notice to respondent number 2 through the by the, there must be a, this thing, prescribed format.
To the office of the public prosecutor.
But there must be a prescribed format if you cannot, this thing, whatever, a legal counsel will be. Do you use that format here?
Format. Lordship, I have to ask the
Uh,
reading assistant.
See, in POXO cases, when you issue sermons, we inform them that if you cannot have a counsel to represent you, a legal aid counsel will be appointed. That little format is there in the
The list of,
notice being issued.
there is, dear Lordship,
There is?
LAC, yes,
Okay,
Lordship.
okay, if there is, then issue notice to the in the prescribed format.
Lordship, first we will see, Lordship, whether they will appear or not, Lordship. Or next step, Lordship, if no one appear, then we'll go to the, go for the
I
list,
think so it
Lordship.
will be through registered post first, okay, because they have
Yes.
been made a party.
Yes, Lordship.
Okay, then if not, then we'll take the
Yes,
next
Lordship.
step. okay?
Yes.
To registered post with AD within 3 working days, returnable by 3 weeks. List after 3 weeks.
Yes.
If it was for a jail appeal and they were not arraigned, then the court will make them a party and then through the, I think.
Lordship.
This after 3 weeks, you want a date?
That can be given, yes. After 3 weeks, okay.
Okay, after 3 weeks.
All right.
Much obliged, Lordship.
Three, 1/5. 15, yes. Okay, Mr. So learned, government advocate, isn't it? For the state respondent have paid for another 3 weeks' time to file their counter affidavit. Praise the Lord. That's the matter after 2 weeks.
If it may please your lordship, I beg to mention item number 7 on behalf of the petitioners here. My lord, can this matter be listed after 2 weeks, your lordship?
Okay, not objected. Richard,
My presence may be recorded.
okay.
Respondent.
Okay, no, mention is made on behalf of Mr. D. Panging. Is it learned counsel for the petitioner for adjournment of the matter which is not objected by Mr.
On behalf of SS Roy, counsel for respondent.
Okay, which is not objected by the council, appearing on behalf of Mr. S.S. Roy, learned counsel for the respondent. In view of the above, this is the matter of the
2 weeks, your lordship. My lord, there's an interim order, your lordship. It may
meanwhile
be extended.
interim order passed earlier shall continue till the next date of the listing.
Much obliged, your lordship.
I beg to mention item number 14. Here for respondent number 1, we have filed out counter affidavit, but for respondent number 2 and 3, we are actually filed your lordship. So this 2 weeks time
Okay.
given your lordship.
Miss so-and-so, government advocate for the state respondents has paid for further time to file their counter affidavit for respondent number 2 and 3. Okay. Praise allowed, list after 3 weeks. Okay, you want your name to be reflected, Mr. So-and-so?
It will be okay.
Okay, a list after 3 weeks, yeah.
Milad, I'm mentioning item number 21 on behalf of Mr. Jumgam Jini. I'm praying for 3 weeks' time to file our affidavit. Reply.
Okay,
May I please, my lord?
yes.
My lord, I am appearing on behalf of Mr. D. Soki. My lord, his name is there in post list. It may be struck off, my lord. He has inadvertently filed the wakalatnama in this case. Actually, he is not representing any of the respondents.
So who is representing respondent?
Yes, it's enough. For respondent 5 to 10.
Okay, 5 to 10.
And my name may be reflected.
Okay, yes.
Lordship, matter may fix on 10th of February.
Mention is made on behalf of for the petitioner,
3 weeks.
who,
On behalf of Mr. Jumgam Jini.
okay, on behalf of Mr. J. Jini, is it?
Yes.
Learned counsel for the petitioner for adjournment of the matter, which is not objected without full stop, which is not objected by Mr. K. Saxena, learned counsel for respondents number 5 to 10. It is also seen that the name of Mr. D. Soki has been reflected in as respondent, as learned counsel for the respondent, and there is a prayer about that the name of Mr. D. Soki may be erased since he is not a counsel for the respondent. Registry to do the
Milad, there's an interim order.
list on, when did you pray?
The 10th of this.
Then-
My name may be reflected.
Yes, okay, no, I've mentioned your name for respondent number, this thing, okay?
In the-
Okay, his name, registry to do the deedful and the name of Mr. So-and-so, learned counsel for respondents number 5 to 10 is to be reflected in the cost list. Then list on 10/02/2026 full stop. Meanwhile, interim order passed earlier shall continue till the next date of this thing.
Oblige you.
I'd like to mention item number 10. Here we have to file affidavit for affidavit, 2 weeks time will be after.
Okay, Ms. So-and-so, learned government advocate for the state respondents has paid for 2 weeks' time to file their counter affidavit. Allowed list on her, give a date. Hmm. 10/02/2026, yes.
My lord, I beg to mention item number 8 and 9, my lord.
Hmm.
It may be adjourned and fixed after 2 weeks, my lord.
Yeah, is your name there in the cost list?
Yes, my lord.
Okay,
Mukbang Pertin, my lord. I'm
Yes,
appearing. on-
yes, is your name is there in the cost list?
Yes, my lord.
Mr.
Mukbang Pertin, my lord.
Okay, M. Pertin, is it?
Yes, my lord.
Mr. Learned Counsel for the petitioner has prayed for adjournment of the matter. Yes, you're not objecting?
I'm not in this.
Then you sit down, which is with the consent from the other side. Okay. Have you taken the consent?
Yes, my lord.
In view of the above? List, after 3 weeks.
2 weeks, my lord, 2 weeks.
Okay, after 2 weeks.
Much obliged.
Lordship, I have to mention about 70. I'm for the response number 4 and the next. So we need some more time to file our application. It has been routed to, it's in the law.
Okay.
My lord, we have taken steps on respondent number 6 and 7. That is the state of Assam and the Deputy Commissioner Demaji. But in our noting also, it is always reflected that their service is awaited. My lord, in case your lordship is giving some time, then we may be allowed to take drastic steps on respondent number 6 and 7 through the Deputy Commissioner Demaji, my lord.
This is in item number 17.
17.
What about 16?
16 also, my lord, we have taken steps and there is a judicial order also that we have taken justice service. And I have submitted the records. That is, my lord,
I think it has to wait for its turn. It's a
2111.
You wait for your turn, we'll call accordingly, okay? Because then, please wait for your turn, okay?
Yes.
It's not simple adjournment, you're making some prayers, so we'll have to see the record. Okay, please wait for your turn. Yes.
Item number 1.
My lord, on the last occasion, the senior government advocate was directed to seek instruction whether any review has been done with regard to the order dated 15/9/2025, your lordship.
Yes, anything?
Instruction review has not been done.
Has not been?
Review has not been done by the department.
Okay, then they have a case.
Yes, your lordship.
So we will allow,
Yes,
if
your
you, because I'll dispose of, I think it is the case. So what is your case?
My lord, it pertains to suspension of the petitioner, your lordship. The order was passed on 15/9/2025, your lordship, wherein it was reflected that the petitioner shall be kept under suspension until further orders, your lordship, which is in violation of section 10(6) and section 10(7) of CCA rules, your lordship.
So review, you're saying should be done after?
Within a period of 90 days. your
90
lordship.
days. So as of today also no
No review.
Okay, when you filed your writ petition, when did you file?
It was filed on 23/12/2025, your lordship.
23/12/2025. So even at the time of filing the writ petition, no review.
No
date,
review was done.
yes, suspension.
Yes, your lordship.
So you are praying for the this thing, squashing of the order dated 15/09/2025.
Yes, your lordship.
I'll pass the order accordingly. Dismissed, allowed? No, allowed and disposed.
Yes, your lordship.
And not dismissed.
Much obliged, your
Allowed
lordship.
and dismissed, yes.
Item number 2.
May I please, my lord?
Hmm.
My lord, in compliance with yesterday's order, I have made the necessary correction in the course title, page number 2.
What was that?
Uh,
Oh, okay, that contempt.
Yes, my lord.
Because previously you have mentioned only the writ appeal.
Writ appeal order dated.
But your contempt is for the compliance of the writ order in passed in writ petition.
Yes,
Isn't
ma'am.
it? Okay, we'll issue notice.
Yes, my lord.
Heard Miss So-and-so, learned counsel for the petitioner who has filed the instant writ petition for the contempt, this thing, petition on the grounds that the respondents have deliberately not complied with the order of this court dated 23/05/2025, passed in WPC number 619/2025, which was upheld wide order dated 16/09/2025 in WA 22/2025. Full stop. the Learned Council submits that the Learned Single Bench in WPC number 619/2025 had passed an order that, the written italics, the remaining part of work is to be assessed and the same is to be required to be allotted to L-1 bidder who is found eligible in accordance with law. Full stop. However, the respondents, wait, and then some order was for quash, is it?
No, my lord.
Nothing. Okay, however, the respondents have failed to take any steps in terms of the court's order dated so and so. Okay. Now, full stop, then issue notice to the respondents through registered post with AD within 3 working days, returnable by 3 weeks. List after 3 weeks.
Did me obliged.
Item number 3.
May it please your lordship.
Yes.
My lord, I'm sorry, my lord, due to some death in my family, I could not be physically present. My lord, here,
What is this petition about?
my lord, the petitioner is challenging a so-called notice, my lord, on two grounds, my lord. One first is, my lord, a rule which is not applicable to the petitioner is being invoked. Second, my lord, on a similar set of facts and circumstances when a criminal case investigation is pending, my lord, departmental proceeding has been proceeded, my lord. Now, if your lordship will kindly come to page 14, my appointment order first, my lord.
Yes.
Page 14, my lord, this, I was appointed as a stenographer 2, my lord. My lord, in the table, serial number 2, my lord will find the petitioner's name. Now, if your lordship kindly turn to page 15, my lord, the next page, my lord.
Yes.
In the down below, my lord will find other conditions of such services which are not specified herein shall be governed by the terms and condition and other relevant rules and order issued by the government from time to time and Arunachal Pradesh State District Court Service Rule 2013. So, my lord, this is the rule which governs my service condition, my lord. Now, this rule, my lord, will find at page 38.
So what does it say about disciplinary proceedings?
My lord. Page 38 is the rule, my lord. Here, my lord, first your lordship will kindly take note of the definition of appointing authority, my lord. Rule 2(1). The authority empowered to make appointment to the category of post which the member for the timing hold. My lord, this is, my lord, here I was appointed by the district and session judge, Teju. So that's my appointing authority, my lord. Now, if your lordship will kindly see, one relevance would be page 41, rule 20 also, my lord. Because as on today, I am on probation, my lord. So, my lord, rule 20 relates to discharge of probationer during the period of probation. Now, my lord, rule 20, sub-rule 2, it says that the order of discharge should contain the ground of discharge, but disciplinary inquiry shall be necessary. Now, rule 23 are the penalties, my lord, which can be imposed.
Penalties.
Yes, these are the penalties. Now, my lord, rule 24 is the disciplinary authority, page 42. So, my lord, what I'm up to is, my lord, this is a comprehensive code which prescribes a punishment, which prescribes a disciplinary authority. So, any action which is contemplated against me can be taken under this rule, my lord.
So who's the discipline authority? Who's taking the action now?
Now, my lord, what happened?
You're
While
not unhappy with what?
I'll come to my lord. Will kindly just take note of one thing, my lord. While I was in service, my lord, on 8/9/2025, somebody, my lord, third person, my lord, has lodged a complaint against me, alleging that I am having a illicit relation with her husband. And in reference, my
So
lord,
whatever the reasons,
no, my lord, there's a reason for it. In reference, it is alleged that there is a violation of Rule 21 of the CCS rules, Conduct Rules 1965. Central Civil Service Conduct Rules 1965. Now, my lord, Rule 21 of the Central Civil Service rules is applicable only for the employee which is appointed by the Government of India. Now, my lord, this rule, 2013 rule, which governs my service condition, does not adopt the CCS rules, my lord. First, my lord.
Where does it mention that? See here, only this thing, appointing authority and the punishment that can be imposed is there. Rest will be governed. Anyways,
Yes.
we'll just issue notice, okay?
No,
the
no,
next
my
day.
lord, no, my lord, I have a, because a discipline, my lord, I'm challenging on two grounds, my lord. Firstly, my lord, the
I don't know if
departmental
you have a
proceeding,
case, but next date,
my lord, departmental proceeding has been initiated against me under Rule 14 of the CCS rules.
It should be under which this thing then of the district this thing service rules.
Service,
Under which this thing?
my 2013
Under which
rules.
section?
Under 2013 rules.
Which section?
Rule 23, my lord.
Rule 23. What's Rule 23?
Rule 23 prescribes the punishment, and Rule 14,
Only
my
the
lord.
punishment.
Yes, Rule 14 of
Rule
the CCS.
It is only the punishment, no,
Yes,
which can be
and
imposed.
my lord, Rule 14, if your lordship kindly take up Rule 14 of the CCS rules, it says, my lord, procedure for initiating a disciplinary proceeding for punishment prescribed under Rule 11 of that rule. So, my lord, it is a proceeding which can be initiated when punishment under Rule 11 is to be imposed.
Okay, that's the first part, and the second part is that there's a criminal proceeding initiated, isn't it?
Yes, my lord. On the same
So
set of
we will
allegations.
issue notice,
My lord.
Yes, we'll issue notice. We are not deciding the matter. Okay.
No,
You
of
have
course,
made your
of course,
point.
of course, my lord.
So you have made your point. So it is sufficient to issue notice. We'll issue notice.
No, my
at
lord,
this
may I
stage.
just point out one thing, my lord. Your lordship will kindly come to page 26, serial number 4, my lord.
What?
Why I'm praying for an interim, my lord?
That will be also considered in the next date.
My lord, page 26, serial number 4, my lord, will kindly see. So and so is further informed that if she does not submit a written statement or defaults on or before the date specified in para 2 or above, does not appear in person before the inquiring authority or otherwise fails or refuses to comply with the provisions of Rule 14 of the CCS rules or order direction issued in pursuance of that said rule, the inquiring authority may hold the inquiry against her ex parte in her absence. So there is a consequence, my lord, of not subjecting myself to the disciplinary authority, my lord. That therefore, my lord, my lord, in my respectful submission, lordship will kindly take note of two things, my lord. There is two substantial question of law which has fallen for your lordship's adjudication, my lord. One, my lord, whether in absence of any provision under the rule 2013
I've
rule.
heard your 2 points. So you are praying for an interim order, isn't it? So leave it at that. We'll issue notice.
Lordship will protect me till the next returnable date. Let the government file an affidavit.
I've heard. Yes, heard Mr. So-and-so, learned counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India for the issuance of the appropriate writ or order to the respondents on the grounds that the petitioner who has been appointed. Where's the appointment order?
Page 14, my lord.
One for her, who has been appointed on 27/02/2025 as a stenographer. By the District and Session Judge Tezu, Arunachal Pradesh. Has been issued a memorandum dated 17/12/2025 under Rule 14 of this CCS within brackets under the Central Civil Service within brackets classification, control and appeal, close bracket rules 1965 and Rule 23 of the Arunachal Pradesh State District Court Services. So this service rules have also been mentioned.
No, my lord, the
Service
first
rules
paragraph, your
for-
lordship will see. For violation of
20,
CCS rules.
30.
First
Okay,
paragraph.
under so and so, by mentioning that the petitioner has violated the where's the first paragraph?
Page 25, first paragraph, violating CCS conduct rules.
Okay, by violating the CCS conduct rules, good stuff. The Learned Council further submits that the said memorandum of charge has been issued against her while there is criminal case. Where's the criminal case?
That, my lord, will find at page 23.
There is a criminal case registered against her under section 351, is it?
Yes, my lord.
351
Subsection 3.
within brackets 3/85 of the BNS for the same set of grounds as alleged against her by the impugned memorandum, is it dated?
Yes, my lord. Yes, my lord.
17/12/2025. He submits that the two matters cannot be initiated side by side till and that the disposal of the said criminal case registered against her has to be disposed of. Good stop. Okay. Then the learned, then we'll issue notice. The learned council submits that, further submits that, no, after full stop, issue notice to the respondents. Anyone accepting full stop?
Respondent number 1.
Mr. So-and-so accepts notice on behalf of respondent number 1. Then how many respondents?
My lord, it should be 2 respondents.
Notice be issued to respondent number 2 through registered post with AD within 3 working days, returnable by 3 weeks, full stop. Then the learned counsel for the petitioner further submits that an order for stay of the impugned order dated 17/12/2025 may be passed since the petitioner is required to appear before the disciplinary authority on
My lord, this letter, this was received on 9/1/2020, so 24 would be the date, my lord. Last date is
On-
24.
Okay, on
24 January.
24/01/2026, failing which her matter is would be considered ex parte. He prayed that the instant that there may be an order for interim order for stay of the operation of the impugned order dated 17/12/2025 since irreparable loss would be since the balance of convenience is in the interest of the petitioner who has been issued to the said memorandum dated 17/12/2025.
I have objection.
Without which is not acceptable and illegal. Good stuff. Then Mr. So-and-so has strongly objected to the issue of interim order, saying the impugned order dated December so-and-so. Good stuff. Okay. On hearing the submissions made by the learned councils, this court, in the interest of justice, find it appropriate to state the operator.
Can I say one thing?
Mhm.
Here was the same set of facts, it's not here. Here was it, see the criminal proceeding. That has been instituted and.
Okay, no, that is the second point, isn't it?
Yes.
If the first point is the this thing, applying the CCS conduct rules, which will see till the next page.
Let us have clarified. What it says, the appointment order law, it says law, the orders or rules issued by the government from time to time also.
So in the next
Definition of-
page, so we'll stay till the next date, then it can,
definitions
it's
of the
a simple
government is
matter.
Definitions of the government is under this very rules. It says the government of Arunachal Pradesh. CCS rules has been adopted by the state of Arunachal Pradesh long time back. The entire government employees are being their conducts, proceeding is being drawn under this provision only.
Malad, this is absolutely incorrect. Malad, I've made a statement on affidavit, Malad.
We'll see in the next date. Okay, till the next date, we'll stay because she's required to appear and everything, then we will see. Because this matter is still going to proceed, even if the writ petition is disposed of, dismissed and disposed of, then it will continue. So it's not till the disposal of the writ petition by the next date. We'll
Now
see.
it will go in the lawsuit. Next day lawsuit. Then
No, then you can.
Let
take
him
up
file the
it.
affidavit on the
See,
next
it's
day,
a-
my lord.
it's a
I am ready to
file,
argue.
It is a file, this thing.
prima facie lawsuit. See the prima facie.
So we'll pass in the next date, okay? Till the next date of listing. Interim order is allowed till the next date of.
Departmental proceeding is for lawsuit that he
Grateful,
has
my lord.
suppressed the material facts that he has married lawsuit at the point of at the time of appointment.
See, whatever.
It's not for lawsuit, this cruelty and intimidation. Criminal case is for cruelty and intimidation, and departmental proceeding is for suppression of material facts of
So
her
next
being
date,
married.
next date we'll see. Okay.
Grateful, my
List, next date, give a date.
Anything convenient to your lordship, my lord. Or my friend to file an affidavit, my lord.
Then it will take time. I have to take instruction from department and it will go on again.
Okay.
Otherwise, Supreme Court says, history cannot be given lawsuit. I have a citation lawsuit.
Okay, then we'll say, see, because this court is in a hurry today. Okay, I don't want to pass long orders, frankly. The prayer for an interim order, okay, is to be considered in the next date after the
My lord,
council.
lordship-
for the-
lordship will
referendum
kindly take-
Number one is to can get this thing, okay, instructions. Okay, we'll
My lord,
consider that. Then
my
we'll
lord-
fix a short date. Okay.
Lordship, my lord, at least till then, my lord, no coercive action against me, my lord. My lord,
Okay,
at least
so
lordship
that
will
will
protect me because
because-
prima facie, my lord. My lord, if your lordship will, what my friend is saying, CCS conduct rules is adopted, my lord. Let him show one order under this rule, my lord, which where they for this rule the
See,
CCS conduct rules is adopted.
council, we will see whether your writ petition has merits or not also.
Absolutely, my lord.
But,
My lord, I prima
but-
facie, my lord,
but-
there is a question of
okay,
law
but
which requires an
We'll issue
adjudication, my lord.
notice, we'll issue notice for this stage, okay? And then we'll just this thing.
Till
List
returnable date, my lord will
after-
fix a short date, my lord will protect me till returnable date.
Yes, give a date.
Anything convenient to my
Okay.
friend, my lord.
List,
No interim may be granted.
okay, list on 29th, okay, 29th, 1/20/26.
My lord,
Yes.
till then, no coercive action, my lord. No coercive action.
Okay,
I'm
till
not saying
then-
stay of the.
Till then, yes, till then, as prayed for by the learned counsel for the petitioner, no coercive action should be taken against the petitioner.
Grateful,
Leave
my
it
lord. Grateful, my lord. Highly obliged.
Just leave it at that. Next date, we'll see. Yes, I'm, this thing considering his submissions also. Okay. Whether he has a case or not, but we'll see in the next date. Okay.
Yes, my lord.
Yes.
Item number 4.
Please, madam.
Yes.
Well, nutshell of my case is, my lord, pertaining to the recommendation for the appointment of Gam Bora in the Kid Bless. Now, my lord, the contention of the bond of contention between the petitioners and the private respondent is, my lord, who should be appointed as a Gam Bora of the that is Kid Bless. Now, my contention is that here before this honorable court, I am here to challenge the impugn order whereby the ADC Mebo has recommended the private respondent number 4 to be appointed as a GB in the vacant post of Kid Bless, my lord. So, my lord, my contention,
Does the appointment
my,
include?
my lord, my contention is only that the private respondent is already over ages. He is more than 60 years and now he is not qualified to be appointed. So there was a vacant, and out of the vacant, myself was a candidate and this private respondent was the contender. These two candidates only. So first of all, I will take to the lordship to page number 58, just to confirm the qualification of the GB. This is the guidelines of the appointment of the GB in Arunachal Pradesh.
Be aged how much?
My lord,
Question is what, aged?
age should not less than 35 years and not more than 60 years of age at the time of his.
60. Okay,
Ah.
so the present person is how old? Who is appointed? Private respondent is how old?
According to me, the private respondent is already 64 years.
Okay.
Because, my lord, in this case, this,
Private respondent explained himself. Okay,
my
I
lord,
to the person
and
appointed.
I'll take the one thing to lordship. Private respondent was already appointed as a Gambura in the years 2009, and this was set aside by this honorable court on a certain reason. This is
Not the age, not the age.
not on the basis of age.
Isn't it?
But yes, but the official record, the record maintained by the state of Arunachal Pradesh, his date of birth, my lord will kindly
So we'll see. So we will see. Let them explain. We don't.
let them
that,
explain it, my lord.
So already he was the Gaungura once, which was this thing. But that does not bar him, isn't it?
His date of birth was in 1961. Dear,
As per that.
yes.
So let them explain them.
My lord. So, my lord, therefore, my lord, yes, let the notice be issued, and in the meantime, my lord, this operation of the impugn order. Otherwise, my lord, this is the 26th January is the occasion where this.
Is he appointed?
No, so far he has not been appointed,
No,
but
the respondent.
private respondent,
Not
appointed, but he,
okay, simply recommended.
yes, recommended by the ADC Mebo, and this maybe is the till that must.
Since it's not appointed yet. Not appointed yet.
Man, this recommendation is final, and this 26th January is the, my lord, this special occasion where the GBs are, head GBs and the GBs are appointed.
No GB now?
My lord, one, other GBs are there.
Okay.
One, after resignation of the 1 GB, this post, Paul Becken.
Heard Mr. So-and-so, learned counsel for the petitioner who has filed the incident petition under Article 226 of the Constitution of India for the issuance of the appropriate writ or order to the respondents by submitting that the respondent number 5, is it?
Format.
The respondent number 4 had issued a recommendation letter, is it?
Sorry, my lord, 5.
Five.
Respondent number 5.
Has issued a recommendation letter dated
7 October 2025 by ADC Mebo.
07/10/2025.
Lots of your against this day.
Okay, recommended on order dated under Mr. No, the respondent number.
5.
He has who has recommended respondent number?
3, my lord.
Respondent number 3.
3.
Has recommended respondent number 5 as the Gaungura of which village?
Kate Village, KIY.
Of Kiat village, which is not as per the, where's the this thing rules? As per the what?
Arunachal
Arunachal Pradesh. What?
Guidelines of the appointment
Okay, guidelines of appointment of,
of the Gaon Bura in Arunachal Pradesh.
okay, Gaon Gura in Arunachal Pradesh. The Learned Council submits that the private respondent number 5 has
Overages.
overage since the guidelines permit the appointment of Gaon Guras up to the age of 60. 60 only, full stop. Issue notice to the respondents, Ms. So-and-so, learned government advocate, accepts notice on behalf of the state respondents number 1 to 5, 1 to 4.
Yes.
Notice be issued to the private respondent number 5 through registered post with AD within 3 working days, returnable by 3 weeks. List after 3 weeks. Full stop. The Learned Council for the petitioner has prayed for the stay of the impugned order dated
7/10/2025.
07/10/2025.
Annexure J.
Appointing for the appointment of,
Recommendation for the appointment of
which is the recommendation for appointment of respondent
5.
5 by submitting that if the respondent number. So now this is for this, then you are saying that you should be appointed or what?
My lord, I'm the contender, but that is the another case. But now at this stage, that his appointment should not be completed. As I have the prima facie case.
By the ADC to the Deputy Commissioner.
My lord,
ADC to the Deputy
my lord,
Commissioner.
that is the my lord final order.
That is my.
No,
Because
once
once recommendation is met,
stay of the recommendation order, which is strongly objected by the learned additional senior government advocate by submitting that this is simply a recommendation to the DC by the additional DC, a recommendation of the ADC to the Deputy Commissioner ECM district, and that no steps have been taken in pursuant of the state letter dated so and so till date. Having heard the submissions made by the learned councils for both the parties, this court finds that there may be no imminent, since there appear to be no imminent.
sorry for interruption, my lord.
Seems to be taken for the with regards to the said impugned order. The prayer for interim order may be considered in the next date.
Sorry for interruption. My lord, my son.
If he's agreed by this order, Lordship, he should have come before, Lordship.
My lord.
No, we'll list in the next date, yes.
My lord, what I'm trying to submit is, my lord, this 26th January is the auspicious occasion wherein, my lord, this ground bureaus are appointed.
On 26th.
My lord, because everything is ready. The recommendation of the ADC is the final.
And then one thing is, are you going to be the thing? Are you supposed to be the Gaon Gura members?
Definitely, my lord. I'll be.
You're going to be, if he's not, then you're going to be.
Definitely, my lord.
He can say that.
That is why I'm here, my lord.
So you'll have to show in the next state that he's the one to be appointed instead of him. Yes, so no interim. Yes. See, unless your name is the second name, okay, and you're supposed to be the Gaon Gura.
My lord.
However, he has been, someone else has been, then you find that something, your whatever right has been, this thing, you should be the one.
My lord.
Okay.
Out of the 2 candidates, my lord.
You're one candidate.
My lord, there was only 2 candidates.
You and himself.
Yeah, myself and this private respondent.
Okay.
And now this private respondent is overages.
Then you will be appointed.
Definitely, my lord.
Then we'll see. That we have to see, because this court does not know how the Gaon Guras are appointed, what is, okay? So in the next date, we'll see, okay? List, then the next date will be after?
After 3 weeks, Lord.
3 weeks. You want a date?
Instruction have to come.
You want a date?
And private.
3 weeks. When? List on, make it 18th. 18 to 20. 26. Okay.
All right.
Item number 5.
Wait, please, Your Lord. My lord, what has happened in this case is that after a, my lord, issuance of an NIT and completion of a tender process, I was declared to be the most responsive bidder. Contract agreement signed with me, LOI issued, and all of a sudden, my lord, the tender was cancelled without any reason.
Where's the cancellation order?
Cancellation order, your lordship will find at page 84. Proper tender process, technically qualified, there were 4 bidders. The NIT was issued by the Rural Development Department, and all of a sudden, they now want to change it. Before that, my lordship will kindly have my contract agreement.
Wait, 84 is the impugned order.
Impugned order.
So you're saying without any reason?
Yes.
So let's see the 84. What is the reason?
Second para onwards. However, the block development officer has submitted a letter stating inability to implement the scheme-wide letter that is, this is 2023. That is irrelevant now because in 2025, NIT was issued by the block development officer. And in addition to this, the Honorable MLA has also requested to change the executing agency. That is the reason, my lord. How can that be?
MLA.
Yes.
Executing, to change the execute. So you are the executing agency.
No, my lord.
Then?
I am the contractor, my lord. The work was settled with me.
Okay, the executing agency gave the work to you.
Yes, earlier, the earlier executing agency. Yes.
Where's the?
Now, my lord will have page 71. Letter of intent in my favor, MS NRK agency.
Okay.
Then, my lord, at
Yes.
next page, my lord, directing me to submit performance guarantee that I have submitted. That's 73. Then 74 is the contract agreement.
Contract agreement
Yeah.
signed, then in between that, the impugned order.
No, my lord, thereafter, at page 76, issue of notice to proceed with work,
Okay.
4th November. This is by the Rural Development Department. Thereafter, my lord, I spent more than 15 lakhs. This is regarding construction of a primary health center. These are the
So you
invoices.
started the work.
Yes. Started the work. I have bought materials, cements, iron rods and all, TMT bars and all. And thereafter, this impugned order comes. The ground is that, my lord, the block development officer in 2023 said he is not able to execute the work. I don't know how is that even relevant.
So 2023. And
Yes, because the NIT was issued in 2025. And the second ground is that the MLA asked for it. How can that be, my lord?
Okay, NIT was in 2025.
Yes, my lord. NIT was dated 21/8/2025.
Okay.
That's irrelevant, my lord. My lord, I am praying for notice, and my lord, they have subsequently issued a fresh NIT, the Rail Works Department. That may be stayed, my lord.
Where's the fresh listing?
91.
Is it the same works?
Same work. Non to hai.
Building of school, is it? Building of compound work?
Yes.
Wall.
Same work, my lord.
Maybe we will issue notice first.
My lord, this is the third party right will be created because the last date is 24th. My lord may state this. My lord may hear the government also, my lord. What is going? How can they do this? They cannot act arbitrarily, my lord. Once you settle it, I spend money on it. How can they do this?
You started the works.
Of course, my lord. I have the invoices, my lord.
Then we will issue notice first. Heard Mr. So-and-so, learned counsel for the petitioner who has filed the instant writ petition under Article 226 of the Constitution of India. for the issue of the appropriate writ or order to the respondents by submitting that the petitioner in response to NIT dated 2108
21/8/2025.
2025 issued by, this is respondent number, Joint Director.
Yes.
They made the respondent.
Yes, yes. This is by the Rural Development Department,
Issued by respondent number
3 and 4.
3 and 4 was selected to take up the works of what? Take up the works of
Construction of,
to execute
yes,
the work of C/O PHE building with compound wall at Mikte/Kudum Circle in West C. Thereafter, the petitioner had taken all necessary steps for execution of the work and had invested how much? Somewhere.
it's around, just a
How
moment.
many
I will
bedrooms?
give the exact figure.
Okay, and had also, okay, executed an agreement with the respondents, wide agreement dated, your affidavit is dated?
My lord,
Dated 04/11/20.
agree 411.
25 for the
14,63,000.
for the execution of the work wherein he had invested rupees
14,63,000.
63,000 towards the work by collecting the required materials, etc. However, the respondents number 2, wide order dated
5/12, page 84.
yes, okay, 05, page 84.
Yes,
But here it is November 2025, 84.
Yes.
Extra 14.
yes, my lord, 5, it is signed on 5/12 at page 86. Last part.
Okay. By order dated 05/12/2025, issued an order wherein
They have only changed the executing agency. There is no mention regarding my tender also, which is already settled.
the executing agency
Yes.
was changed from respondent number
Rural Development Department to
there-
Rural Works Department.
from Rural Development Department / respondent number
Respondent number 3 and
3
4,
and 4 to respondent to which Rural
5 and 6,
Works Department /
Rural Works,
respondent number 2 and
5 and 6,
2 and 4,
5 and 6.
5 and 6. Without any reasonable reason given. There is also no mention regarding the works already allotted to respond the petitioner in the said order. Aggrieved by the said order dated yes, this thing, what is the date?
My lord,
Aggrieved by the said order.
5/12/2025.
Yes, 05/12/2025, the instant writ petition has been filed. Issue notice to the respondents to then Mr. So and so, who is accepting notice, addition, accepts notice
and 7.
on behalf of respondents number 1, 2, and 7, Mr. So and so accepts notice on behalf of 3 and 4. Mr. So and so accepts notice on behalf of respondent number 5 and 6. no need to issue formal notice. Requisite copies of the writ petition to be duly furnished to the learned councils. Any private respondent?
No.
Then full stop. The learned counsel for the petition of further state has submitted that the impugned order dated 05/12/2025 may be stayed, since the order is also for the issuance of a fresh NIT.
The NIT has already been issued, my lord, page 91, so that may be stayed.
Okay, also submits that on the issuance of the impugned order dated 05/12/2025, a fresh NIT dated, where is it?
10/1/2020.
10/01/2026, okay, has also been issued. Full stop. The learned council submits that unless this fresh NIT is stayed, the interest of a third party may also be involved. Full stop. On hearing the submissions made by the learned counsel for the petitioner, this court find it fit to stay the operation of this.
Let me submit. Since as per the allocation of business, construction of building of Sajeta has to be constructed by the RWB. So since there was, in the meantime, after closing of tender by the RD, the work was not started. Then in the meantime, as per the allocation of business, they have changed the executing agency.
So
No, that's not
so we'll
correct.
stay for the
Yes.
time being, okay, because he's has some grievance. If that NIT is this thing proceeded with, then who is going to do the work when his this thing is not mentioned also? So let us look into that as to why the order was, okay. We'll stay till the next date of this thing.
Process was initiated in 2023 itself.
Okay, there's a prayed for the stay of the fresh NIT dated so and so, which is objected by, strongly objected by Mr. So and so. Learned Standing Council for respondents number
5 and 6.
5 and 6. Wisdom. This court, however, finds it appropriate to stay the operation of the fresh NIT dated so and so till the next date of listing. Yes,
Obliged, highly obliged.
after 3 weeks.
Yeah. Obliged.
Item number 6.
May it please your lordship. I am challenging the letter at page number 18, my lord.
Yes.
Well, this letter has been issued for recovery of an interest amount, my lord, without there being the so-called proceeding, my lord. Neither so-called was issued nor any hearing opportunity was given, my lord. Simply this recovery notice has been
Interest
issued
of what?
on delayed payments of taxes, my lord. But there is a requirement of issuance of so-called notice. Without there being an adjudication, my lord, they have simply issued this notice, my lord.
Where's the order, impugned order?
Page 18 is the letter, my. There is no order. At page 18, the order is there. The letter is there. Recovery letter.
Letter.
Letter only,
recovery
ma'am.
Letter, page 18.
Page 18, my lord.
That part. Okay. So the impugned order is this one.
There is no.
dated What?
There is no order, my lord. They have, on a basis of some report, my lord, they have simply issued this order. There was no order, my lord. This letter is there only.
Notice for recovery of proceedings.
Yes, ma'am.
Is it?
Yes, ma'am. This notice, my lord. I am
Okay.
challenging this notice, my lord, because there is no so-called, there is no opportunity of, there is no
Without
education order.
any issuance of notice to you. Is
Yes,
it?
my lord. No, in fact, ma, there is no order at all, my lord. They simply issued this letter, my lord. There is no education order, my lord.
Okay, I heard Mr. Sawan,
Yes, Mr.
learned counsel for the petitioner who has filed the instant writ petition under Article 226 of the Constitution of India for the issuance of the appropriate writ or order, being aggrieved by the notice for recovery proceedings under Section 79 of the GST Act 2017 dated
24/10/2025.
10/2025 by submitting that the instant notice for recovery proceedings was received by the petitioner without any show cause notice issued to the petitioner. Full stop. The learned counsel submits that issuance of such a notice without giving a chance to the petitioner is in violations of the principle of natural justice. Full stop. On considering the submissions made by the learned counsel for the petitioner issue notice of motion to the respondents. Yes, Miss.
While appearing on behalf of M. Karthik.
Welcome. Appearing on behalf of Mr.
M. Karthik.
M. Kato, the deputy leader, accepts notice. Anyone else?
Yes, I accept notice on behalf of respondent number 1.
Notice on behalf of respondent number 1. Notice be issued to respondent number 2 and 3 to registered post with AD returnable by 3 weeks. This after 3 weeks, full stop. Requisite copies of the writ petition to be duly furnished to the learned counsel for response.
I will interim prayer, my lord, because in the meantime, they may recover this amount, my lord.
On the submission made by the learned counsel for the petitioner, this court find it fit to stay the operation of the impugned notice dated so and so till the next date of listing.
No, there are total four respondent, my lord. Lordship will issue notice to 2 and 3. Lordship may also notice to 4 also.
To the respondent number 2, 3, and
4, my lord. Much obliged.
yes.
हम दार्जिलिंग में जा रहे थे नेपाल बॉर्डर पे हम पूछता है तो नेपाली से बोलते हैं कुछ नहीं पूछता हमको मधेसी बोलते हैं मधेसी है
चलो एक्सपीरियंस
होता है
Item number 11.
Well, this item number 11 and 12, my lord, the state is yet to file the affidavit. So
Okay.
I have sought the consent of my friends. May it be listed on 2nd of Feb.
Okay.
By the time the state council will file the affidavit, and then I will also file my rejoinder.
Rejoinder on
Yes.
that day.
Oh, my lord, this matter otherwise is very urgent. There is urgency, my lord. Matter being, my lord, this validity of the supply order is still March only, my lord. So otherwise,
2nd February.
so this, my lord, may kindly make
But
the,
there's an interim order
yes, my lord, that's why, my lord.
already in interim.
No, my lord, the difficulty is that the case has to be disposed on the basis of the affidavit filed by the state respondent.
Okay, so you need time to file your rejoinder.
No, my lord. State
Okay.
will file the
Not yet
affidavit, not yet filed.
Within 2-3 days, we will file.
Okay.
Then
Then
my-
fix a short date. huh?
Yes, my lord, kindly it may be noted, my lord, that no further adjournment and my lord, rejoinder, if required to be filed, it has to be filed within the
You're
next
for
day.
the private respondent.
I am for the private
Okay.
respondent.
mhm. We'll fix, heard, Mr. T.T. Tara, learned counsel for the petitioners, who prayed that he may be given time to file a rejoinder affidavit after the state respondents have filed their
No,
counter
no,
affidavit.
my lord, may I just assist, my lord? Submits that the state respondent has not filed the affidavit in opposition yet. After filing,
So after they file, I've mentioned.
I will file the rejoinder.
After, so we have mentioned that after the state respondents file their affidavit. Then Mr. So-and-so, learned standing counsel, is it, for respondents number 1 to 5, submits that he will be filing the counter affidavit
Correct.
within a period of
Within a period, 2-3 days.
2-3 days. Full stop. Then Mr. R. Sonar, is it, learned counsel for the private respondent, has expressed urgency in the matter. In view of the above submissions, this court find it fit to fix, give a date.
2nd Feb.
2nd Feb. 28 and 29, I have fixed matters in principal bench, my lord.
Okay,
So
so
I-
a second, on 02/02/2026, by which the learned Standing Council for respondent number 1 to 5 should have filed their counter affidavit, and thereafter the Learned Council for the petitioner may also file their rejoinder affidavit, okay, by the next court
And
date.
my lord, my brother has some prayer. Endeavor shall be made to dispose of the read
Okay.
petition on 2nd Feb.
My lord,
I
there's an
think
urgency.
You should be happy.
Okay. List the matter on so and so we've done, wherein an attempt will be made to dispose of the matter at the admissions stage itself. Okay. Then interim order passed earlier.
Yes, I'll continue.
till the
till
next date of list.
I am grateful, my lord. Item number 12 also same order. my lord.
Same order.
Same.
Item number 13.
Yes.
Your Lordship, I respectfully seek some time for pleading the new incumbent as the previous incumbent has been transferred.
Okay. Heard Ms. So-and-so, Learned Counsel for the petitioner who has prayed for time to file an impediment application on the transfer of respondent number 2. Stop. Praise aloud. List after 2 weeks. Okay, full stop.
Yes,
Then the presence of Mr. So-and-so, Learned Counsel for
R3, respondent number 3.
respondent number 3 is noted.
Always.
Obliged. Item number 16 and 17.
But in item number 16, this case was filed on 29/1/2025, almost a year. But neither the government has filed their affidavit nor the NSPC. We have taken steps on the NSPC. We have also served the dusty service as directed, and that has been recorded by your lordship's order that 21/11/2025. But despite that,
Affidavit, so you have submitted that steps have been taken through Dusty. So affidavit that to that effect have been filed?
oh yes.
It's filed. Where?
Oh, no, my lord, affidavit as such has not been filed.
Then you file. That the thing, then you can say that Dusty the thing, the service is complete, isn't it? So now you see you have taken steps, but you have to file an affidavit to that effect. Okay. So Mr. So-and-so, Learned Counsel for the petitioner is present and submits that he has taken steps for service of notice upon respondent number 5. He will be filing his affidavit to that effect by the next court date. Okay. Then in view of the above, list.
My only submission is, my lord, this is pertaining to compensation. My lord, state government has already, there was a earlier writ petitions, number of writ petitions. There they have, the moot question arose whether the land which is already under use by the NSPC, they have been acquired or not properly. So it was admitted by the state additional advocate general that it was not acquired. And only on that basis only your lordship has directed that this we should suggested that we should file a writ petitions, and then the issue of acquisition should be taken up. Now this only question is whether the in view of the order observations made by the advocate general admission, maybe on the on the next date, an attempt will be made to
Okay, but who is this respondent number, this thing, 5?
this is the general manager of the NSPC.
We are the NSPC, and we are yet to be engaged by NSPC in item number 16.
So this is this thing, service is not complete. No? You file your this thing affidavit, then we can say that service is complete, whether they're represented or not. They're important, I think, in this writ petition.
No, in that case, because they are only the user agency, it is between the state government and us, as land owners, basically. So,
but the user, if they are not there, they'll have something to say, I think.
it is an admitted fact that no acquisition was carried out.
Where have you admitted? Where's the government?
My lord, Your Lordship may kindly come to the, my lord, I have,
Have you filed your counter?
no, my lord.
No, Your Lordship.
Then file your counter.
Almost 1 year now.
So we'll give you this thing, last chance, failing which appropriate orders will be passed then. Okay, when was the order? January 2025. You have to file.
Sure.
Okay, whether this
My lord,
thing.
my lord, just, my lord, just for academic purpose, my lord, may I just take Your Lordship to page 127? 127. My lord, 120, Your Lordship may kindly come to 128. And my lord, Your Lordship may come to paragraph 2, 129, my lord. This court during the course of hearing had also inquired with Mr. B.D. Goswami, the learned additional advocate general, government of Arunachal Pradesh, as to whether any proceedings have been initiated under the applicable acquisition acts. The learned additional advocate general submits that to his instructions there is no acquisition proceedings initiated. However, there were certain attempts being made to make settlements so that the project of the National Hydropower Electric Power Corporation could be set up. Now this, my lord, this already has been set up. It's already in operation.
Same WPC.
Yes. No, this is another WPC. And since, therefore, we have.
So you have mentioned this in your, this thing also, no? In your petition.
Yes.
Concerning this.
Yes.
So let me them reply to this, okay? You have mentioned the submission made by the learned additional.
Yes, we have.
In this,
in
in the
petition.
writ petition
Yes.
enclosing this. So they will have to reply to that also,
Well,
whether this pertains to the same thing and they admit here also,
Yes.
isn't it?
Yes.
You cannot put the words
Let them, my lord,
out in this.
if not affidavit, written instructions.
Instructions.
Yes, at least instructions, my lord.
Concerning this matter.
And then we will make an attempt to.
Yeah, okay. So what was the last sentence? Okay. And you will be filing his affidavit to that effect by the next court date. Stop. Okay. It is also seen that the state government respondent number
1, 2, and 3.
1, 2, and 3 has yet to file their counter affidavit, if any. Okay, then you're for
I'm at number 17.
He's in 17.
17. What about all the others?
That's what, my lord, steps we have taken, they have received the copy also, but they are not appearing.
Okay, then Mr. So-and-so, learned counsel for respondent number 17. Are you going to file your?
No, Lordship. In item number 17, I'm for 4 and 5.
Okay, 4 and 5. That's what.
He's not the, right now.
If you are saying 4 and 5.
In item number 17.
17. Okay, this is 16. Okay.
This is 16.
You're here for anyone? Okay. That you will be filing. Okay. On considering the submissions made, okay, then Mr. So-and-so, learned counsel for the petitioner submits that the state governments in the case.
Page 127, madam. During the course of hearing of WPC number.
In the case WPC 4978/2024, during the course of hearing.
Paragraph
had
2 maybe.
admitted that no acquisition proceedings were initiated as noted by this court in its order dated 21/11/2024. In view of the above, the learned government advocate may get instructions in this regard. Good stop.
Only on this point only.
In this regard, on this point, the learned counsel for the petitioner has also expressed urgency in the matter. In view of the above, considering the submissions made, this court find it appropriate that an attempt may be made to consider and dispose of the instant writ petition at the next date, provided notice is complete upon all the respondents. Yes.
My lord, it may be listed in the admission column, my lord, so that we can
No, it cannot be. Don't brush because service of this thing is not this thing. Okay. In view of the above, if notice is complete upon all the upon respondent number 5, matter may be listed in the admission column. Okay. But file here this thing affidavit first that notice is complete. Okay.
My lord,
then
a
we'll
fixed
see.
date may be given, my lord.
Fix on.
Second week of February.
Second
week of February.
So give a date.
11th.
Okay, 11/02/2026. Now we have been fixing dates. If too many cases have been fixed on a certain date, fixed date, then you please mention. Okay.
Yes.
Now, item number 17.
Yes. In item number 17, my lord, we have taken steps initially on 8/4/2025 because this was filed in the month of April. So on respondent number 4 to 7. This is 4 and 5 is the NSPC, 6 and 7 is the State of Assam and the Deputy Commissioner, Dhemaji district.
On when? Which was the last date?
On 8, you lordship may kindly come to the or note sheet of 8/4/2025.
So you want to take fresh steps?
No, we have already, they are appearing. Only my submission is, my lord. If at all we are fixing this on the same date on 16. So, my lord, in this case, I may be given liberty to file a dusty service to 6 and 7, but through Deputy Commissioner Dhemaji, my lord.
Are they the party?
Yes.
Who is Deputy Commissioner?
Dhemaji, Assam.
They
Respondent
are
number 7.
Number 7. So
Yes.
just say, so you want to take steps for service of notice upon respondent number 7 through Dusty.
6 and 7.
6 and 7,
Through Dusty only. My lord, we have taken the registered post.
So
Only
that-
Dusty.
Leave it, So your fresh play is 6 and 7.
6 and 7.
Through Dusty mode. We also
Yes.
want to.
Only,
Yes, I've understood her, Mr. So-and-so, learned counsel for the petitioner, who prayed that he may be allowed to take steps for service of notice upon respondent number 6 and 7, since AD card upon the said respondents is not returned till date. Stop. Praise the Lord, learned counsel for the petitioner, may take steps for service of notice upon respondent number 6 and 7 through the Dusty mode, and affidavit to that effect is to be filed accordingly. Stop. Then, Mr.
My lord, only one
Yes.
submission, my lord, because it should be through the respondent number 7, because Deputy Commissioner will submit 2 copies for the state also and for the Deputy Commissioner also. If your lordship, through the Deputy Commissioner, Dhemaji, to respondent number 7.
Then, I don't know whether that will be this thing, Dusty, because you have to take this thing service, because respondent number 7 is also a party. So you give it to him, and then
My lord, let there be a judicial order,
they'll have to sign.
because that case we have
Because
both.
then, why are you giving the trouble? He might not be willing. Respondent number 7, you have to take the steps. You're the distinct petitioner. Don't make them do your homework, isn't it? And then, Mr. So-and-so, learned government advocate, for respondents number 1 to 3, has paid for time to file their counter affidavit. Well, Mr. Arun Thugong, is it, learned counsel for respondent number 4 and 5, is it, has paid for further time to file his counter affidavit. In view of the above submissions, list again same date on so and so.
9, 11, no? Obliged.
Item number 18 and 19.
May I
Yes,
please?
written objection not filed by the state respondents.
Lordship, since there is no instruction, we will not file lordship.
You'll not be filing, then who
Private
is the
respondent.
private?
I have already filed.
Filed.
They have filed.
Okay, then pleadings complete?
Yes, pleadings are
Are you
complete.
going to file your rejoinder?
No, Lords.
No. Okay, Mr. So-and-so, learned counsel for the, oh, this is an IA first.
Yes, IA first.
So
Yes, Lord.
the IA,
Yes.
what is the IA about?
Lord, see, through IA, we are praying for injunction against the private respondents. They are cutting trees in the disputed land. So we are objecting to that, all those activities.
Within the disputed land?
They're felling trees.
Planting trees?
No, felling trees. They are cutting,
trees.
yeah, they're cutting lumberjacks.
Planting trees now?
This is not a disputed land, Lordship. By cover decision, Lordship, the ownership has already been declared in our favor, Lordship. And that cover decision has never been put to challenge by the petitioner, Lordship. So, which means, Lordship, it has attained its finality, Lordship. No, Lordship.
Will be listed next.
The ownership is not disputed. Lordship, we are the owners because, of course, as per the Kebang decision of 2000.
Dispute, obviously.
Yes.
You're saying it's not.
Cover yes, Lordship. There is a cover decision that has
So
not
that
been
we'll
challenged.
have to see, that is your stand.
Yes.
He's saying he's the owner.
Yes,
So
Lordship.
that's why the case is here, isn't it? If we say he's not the owner, then we cannot accept. Anyway, heard Mr. So-and-so, learned counsel for the applicant / petitioner, along with Mr. So-and-so, learned counsel for
Private respondent number
private
3 to 10.
respondent number 3 to 10. And Ms. So-and-so, learned government advocate for the state respondents. It is, the learned government advocate submits that since she has not received any instructions, she will not be filing any written objection. Stop. It is seen that the private respondents have filed their written objection. In view of the above, matter to be listed on her next week. When do you want it?
Next week will be fine.
For disposal.
Yes,
next
for
week
disposal.
The disposal of the instant IA.
Yes, okay.
Yes. Okay, then in the writ petition also, what is the stage here?
Pleadings are exchanged, already exchanged.
The counter affidavits filed?
I have filed.
We have also filed.
Okay. That is all, so in the main, the same WPC, the learned counsels for both the parties are present and it is seen that pleadings are complete. Matter may be listed for admission hearing. Okay, same date, during the first week of, no, in the next week. No.
Next week?
Matter may be listed, we have to make listed in the next week, Okay, so because the IA is also going to be listed in the next week. So we'll list the matter next week, then accordingly, after the disposal of the IA, whether a hearing is going to be held or not, that will be seen. Isn't it?
Any fixed date, if it's possible, Lordship.
Next week, give a date then for the IA and this same date.
For the main petition, Lordship.
It has to be along with the IA. They are going to be listed together. We
Yes.
cannot make it separate,
30.
isn't it? So next week, any date?
It will be on 29th also.
Yes,
On,
29.
29/1/2026. Yes.
Deeply obliged.
Item number 20.
May I apply your lordship?
Yes.
Well, in this item 20, in the main petition, we are yet to file reply to the counter affidavits. And in IA, we have filed the reply, your lordship. So, my lord, some more time have given and we can file the counter affidavit to the reply to the counter affidavit and matter can be fixed for the
Okay.
admission hearing, my lord.
What is the IA about?
IA is basically
Modifications of the interim order laws.
It's for modification
For
of the
modification.
interim
This is
order.
by me, lordship, the state government.
Oh, by you?
Yes, lordship.
But IA which he has prayed is almost disposal of the writ petition, my lord.
No, not like that.
Because they are
So both the matters will be considered. Okay. Now, in the writ petition, pleadings complete?
not complete, my lord. So we want to file the reply to the counter affidavit, my lord.
So let's pass an order, the IA fix the next date. Mr. So-and-so, learned counsel for the
Yes, Lordship.
petitioner is present along with Mr. So-and-so, learned
sir.
counsel, standing counsel, is it? Learned government advocate for the state respondent.
Lordship.
Okay. It is seen that the opposite party, you're the private, isn't it?
We are the petitioners, my lord.
The opposite party slash petitioners have filed their
Reply to the IA, my lord.
no, have filed their written objection, isn't it? Who-
Yes, we have filed.
So it has to be written objection.
Yes, yes, we have filed written objections.
To the IA filed by the applicants. In view of the above, the IA is to be considered, give a date on.
Lordship, today it can be taken up by IL, Lordship.
No,
Urgency is there, Lordship. A
so we'll
particular,
fix a short date, okay. We'll fix a short date because I have a very important hearing. If you can see, resolve bench, so I'm in a bit of a hurry.
then tomorrow, Lordship,
No, not tomorrow, because this court, on Monday, on Tuesday.
Tuesday.
Hmm.
Tuesday.
On Tuesday.
27th.
My lord, matter is, my lord, is disposal of, considering the IA is almost disposing of the writ petition.
so-
So we want to file the reply to the writ petition.
We listed, since there's been listed the next on Tuesday, then depending on the, then you make your submissions, then the bench will decide
Right.
whether the IA should be disposed of along with the writ petition
Sure,
or
sure.
disposed of separately. Okay.
Lordship,
Right.
there's
That's the liberty.
the previous
Yes,
order
sir.
of the Supreme Court, Lordship. The IL we consider, Lordship.
Wait. Wherein the IA may be considered if found appropriate. Okay.
And otherwise, Lordship, here, Lordship, affidavit was filed on 2nd of December and copy was served to the petitioner. Now he's asking time to file affidavit in reply. Enough time they have already taken.
What in the this?
In
No,
the-
no, it happens. Counter also they keep asking, so it depends. Anyway,
Yeah, please.
so in the writ petition, Mr. So-and-so, learned counsel for the petitioner is present along with Mr. So-and-so, learned government for the state respondents. It is seen that, full stop, the learned counsel for the petitioner has prayed for time to file his affidavit in reply to the counter affidavit filed by the state respondents. Accordingly, list the matter along with IA number so-and-so on.
10th February, my lord.
No, we had fixed a short, he has expressed urgency in the matter
27, Lordship.
along with the
27.
thing. Then on the 27th, if for any reason you find that the IA cannot
Obliged.
be disposed of separately, you make a submission.
Then,
It will be considered because the whole thing has to be heard anyway.
my lord, then 28, my lord.
Why?
28, some other,
Okay, one day, let's.
one day, so 28,
28.
Yes.
02, 2020, so both, okay, the IA and the.
obliged.
Item number 22.
Well, the purpose of filing this writ petition has been achieved. The petitioner was elected as Gram Panchayat member, my lord. Then after compliance of the section 60, rule 60, sub rule 4 of the conduct of election rules, once the returning officer issues form 23, he becomes functus officio. But unfortunately, my lord, what had happened by impugn order dated 19/12/2025, the ADC, come returning officer, has suspended her membership. That is, dehorsed the rule 69 of the conduct of election rules. Any dispute arises thereafter, my lord, so by means of election petition. Now, pursuant to the stay order granted by this honorable court, I fill up the form for chairperson Gram Panchayat, GPM, GPC. Then I am elected, my lord.
Okay, now elected.
I am elected now. I have also been sent for training. Now,
So the petition, you need not pursue?
Uh,
Or you still,
that's-
then there are no grounds to pursue the.
subject, but
If she's been elected,
So she was already elected at that point of time only.
That point of.
It was kept in abeyance, which is under challenge in the present writ petitions.
Okay.
Certificate of election was given to her, and that has been kept in abeyance due to subsequent development lawsuit.
Oh, okay.
And because of the
Petition has been kept.
yes, because since interim order was passed by the Sonoma Court,
Oh.
so on that basis, he has contested for the chairperson also.
So
In terms of the interim order passed by the Sonoma Court, only he has contested the Gram chairperson. Gram chairperson is separate.
separate.
Yes.
Okay. So now the
Now,
writ petition.
as per last order,
Yes.
I was directed to bring instruction laws.
Okay.
So as per instruction laws, one has to be registered, enroll in the e-roll, the roll as a voter
Okay.
to contest the post of GPM. But her name is not there in the list.
So that
By committing fraud, he has contested and he has been declared, and which was subsequently it was detected. So anyway, I may allow to file this my instruction.
Yes, by way of an affidavit, I
Yes.
think, so that he can also file
Yes.
this thing. huh,
Then I may be
reply to
given
that.
1 week time to.
Okay. Mr. T.T. Tara, learned counsel for the petitioner is present along with Mr. So-and-so, learned government advocate for the state respondents. You are, and Mr.
I'm appearing for all the private respondents.
And, okay, Mr. So-and-so appearing for all the private respondents. Good stuff. The learned government advocate submits that he has received the necessary instructions and prayed that he may file the same by way of an affidavit. Yes. Then, what about you? Are you going to file any affidavit?
Yes, Lordship. Lordship, I haven't received a petition copy.
Okay.
Petitioner may be directed to serve a petition.
Yes, the learned counsel. for
Steps, my lord, we have already taken steps.
So he's for the private.
Yes,
So you give, okay? I don't think that requires to be reflected. Private
Today
response,
only, Your Lordship, I have filed my vakalatnama.
okay.
Fine,
okay.
fine, fine.
Because of
That's-
that, then give, okay? The learned counsel for the private respondents also submits that he will be filing his counter affidavit after receiving copy of the writ petition. Okay. In view of the above, list the matter after
Filing of the after
after 1 week. Okay.
interim order to continue.
Is there interim order?
Yes.
Interim order passed earlier shall continue till the next date of listing.
Fine, right.
Item number 23 and 24.
What's the hearing matter?
This is Lordship with regard to land compensation, for payment of land compensation.
Now, if this requires an extensive hearing, okay, I think we'll list in the next week. Okay, next week. When do you want it?
Particular date
In the
may be
beginning, because this court is only going to sit till tomorrow and going to a different place.
Yes, after
10 February.
after the short date may be fixed, Lordship.
10 February. madam.
Today is 20 and 27, 20. Can this matter be on 29?
Well, let it be on 10 February or
Because it is too late, the land compensation matter.
No, but that will take time. There's no urgency. Land compensation, especially if a writ petition is allowed, will come very.
3rd of February.
It is the petitioner who should be pressing, so when, 3rd February.
February.
Both of you have to be available. That's why we asked for a date so that the councils are both available on that day. Isn't it?
Council is available today.
But this.
On the previous occasion, he is, my friend is.
Fix a date when he says when he wants it so that he's definitely available,
on
isn't
the-
it?
On
Yes.
3rd February.
3rd February.
Mr.
Aye,
So,
thank you.
learned counsel for the
Hold on.
petitioner is present along with Mr.
Aye.
So-and-so, learned additional AG for the
Clustering,
state
huh?
respondents.
Can this matter be on 9?
Okay,
Nine.
on 9,
Yes.
on the submission made by the learned
Directly.
counsels, for both the parties, matter may be listed on 09/02/2026. Yes.
Obliged, ma'am.
This thing, Aizawl Bank, I will leave and then I'll come back. Okay, we cannot continue like this. You tell the Aizawl Bank after this. Yes.
May I please, Your Worship?
Yes.
My lord,
Item number 1 related to Aizawl Bench.
my lord, in review petition, my lord, my learned friend is appearing for respondent 4, my lord, my friend, my lord. This matter related to contempt matter is fixed on 6th of February today, my lord. So both of we suggest, my lord, this review petition and contempt petition may come along with on 6th February, my lord. Contempt is 8 of.
Wait. So you have prayed for a review of the
Yes,
judgment of this court.
Yes,
And
ma'am.
then what about the contempt? How is it connected with the contempt?
Yes, my lord, the assessment was made by DC, my lord. That assessment after, my lord, they filed contempt, my lord. And we challenged that assessment, my lord, DC assessment, my lord. DC assessment filed in WPC 1 on 2, my lord, which was dismissed by your lordship, my lord. That order is reviewed, my lord. And my lord, the
Okay,
contempt.
for review of that order, huh?
Yes.
So now the contempt is still there?
Yes, ma'am.
Contempt petition.
Today it was
So
listed, my
then
lord.
it's the same thing. Again, it comes up to the same thing.
No,
Because
ma'am,
previously also the review and the writ petition.
No, my lord.
Yes,
My
my
lord. May I submit,
Miss
my lord?
Valentina. Yes.
What we suggest, my lord? She also suggests, my lord, come along with, because
So let her, you don't speak for her. Let her say, yes, Miss Valentina. Are you also praying for the same thing?
My lord, the fact is that this review petition cannot be maintained because it arises from the WPC 148 of 2018, which was decided on 19/3/2020. Thereafter, accordingly, verification team was constituted. The Honorable Court gave a direction to the respondents to either acquire my land or to vacate my land and to pay me a rental compensation. So only two options are there. However, the respondents themselves has not complied with the said order. Verification was constituted and accordingly 4 times verification was done. So either they vacate or they pay me a rental compensation. That's the only options left. Hence, we have to file the contempt petition, which is still pending now. Contempt petition was filed in the year 2022. Now it's only to 2026.
So supposing the contempt petition, which has been listed maybe in the next week, is disposed of, then will this review petition have any meaning?
Infructuous, my lord.
It becomes infructuous.
Yes, ma'am.
Then we'll fix another date and we can await for the disposal of the contempt petition.
My lord, thing is that, my lord, this lordship made and then turned the page on 207 of the order of this Honorable Justice. My lord, here, my lord, is clear, my lord. This I am reading, my lord. From paragraph 2, my lord. Review petitioner prayed for review of an order of 19/3/2020 passed in WPC number 148/19, whereas respondent directed to constitute a verification team to verify as to where 2 plots of land of the petitioner then should be acquired under right fair compensation X so and so, and or he should be paid damage for damage cost so and so. The learned counsel for a review petition submitted this court by in order that 19/3/2020 had directed the two plot of the land covered by periodic DUG number so and so shall be verified in terms of direction of the past as above. However, it is now been ascertained that after verification that periodic patta number so and so belongs to petitioner now of the WPC number 148/19. And other covered periodic patta so and so belongs to the wife of the petitioner. He accordingly submitted there should be a review of the order that is so and so as much as the review petitioner WPC was not owner of the land of the plot of land. The court, the outstate find that the direction passed by order dated 19/3/2020 WPC has been complied with. This is already complied as per the court order, my lord. This is the court they observed, my lord. The contempt already complied, my lord. And in as much
Okay,
as
then in that case, we will file this after the contempt petition.
my lord,
which is listed in
therefore paragraph 5, my lord. Review petition had to challenge the assessment. I've challenged the assessment damage payable to the petitioner and his wife made by district collector by the of WBC number so and so. This is the assessment, my lord. They filed the contempt petition, my lord. This is the, my lord. However, WBC number 1 so was dismissed by coordinate bench of this court on the ground that the LS non-compliance of the impugned order dated so and so 19/3/2022 WBC number 48/19 and verification report are the issue and contempt case number 8 of 22. Further, contempt case the 80 of 22 court have given liberty to review petitioner herein to file the present review petition. So, my lord, this is interrelated, my lord, contempt and my lord. On considering the fact that the direction passed by this court in impugned order dated 19/3/2022 passed WBC has already been complied with. There is nothing to be reviewed. If the review petitioner is not happy with the verification report and contents therein, same should be put in challenge by the web appropriate petition before the appropriate forum. If challenge is failed, there is no bar to review petitioners to approach the higher forum. Also, appeal also, my indication is there from with the grievances. However, there as no ground in the review has been made out, the review petition this is the order of the review, my lord. So, my lord, the contention, my lord, the order, my lord, the observation is, my lord, the assessment which was now is the contempt petition, my lord. That also the challenge in the WPC 112, my lord, and read petition, my lord. So these are the interrelated. So may I pray, my lord? May I pray?
Yes, pray.
Both the matter related. So your lordship heard the matter, my lord, because already this the review was order, my lord. Honorable Justice of the Coordinate Bench, when review passed on the order, my lord, says that the contempt order is already complied with. The contempt and the already order is complied with of that order, my lord. So now question is the assessment and the verification report. I have challenged that said verification report. So on the basis of the compensation assessed by DC, my lord, that was the in contempt petition, my lord. So may I pray, my lord, nothing will happen, my lord, nothing will the heaven will not fall, my lord, because on 6th of February that case is there. So my prayer before your lordship, this as both are the same issue. So your lordship heard together, then everything will be clear.
Okay, I think we can do that. Okay, heard Mr. S.K. Medi, learned counsel for the petition. Also, full stop. Also heard Ms. Valentina Laldinpui, learned counsel for the respondent.
Respondent 4.
On the respondent number 4, is it?
Yes, my lord, 4.
Who is 1 to 3?
My government
Okay, and Ms.
On behalf of
Sawant.
Ms. Vanna Isyami, Additional Public Prosecutor.
Okay, and Miss, your good name, please?
Lalsang Zeli.
Lalsang Zeli, appearing on behalf of Ms. Vanna Isyami, learned learned government advocate, okay, for the state respondents. On the submissions made by the learned counsels for both the parties, this matter may be considered along with the contempt petition number
8 of
2022.
8 of
2022.
2022.
Accordingly, this matter along with contempt petition number 8/2022 on which date?
6 February, my lord.
On 06/02/2026. Yes.
Yes. Highly obliged.